Good morning. My name is Michael Hauser. I'm an attorney with the US Trustee's office. Today is August 5th, 2019. This is the Chapter 11, 341 meeting of creditors in the case of Ultimate Brands, Inc., case number 8:19-12516 TA. Counsel for the debtor, could you please make your appearance for the record?
Julie Villalobos on behalf of the debtor.
Okay. Mr. Griffiths, could you please state your name for the record?
William Scott Griifiths.
Okay. Could you please raise your right hand?
Mm-hmm.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I will.
Okay. I'm just going to need you to raise your voice just a bit.
I will.
Okay. Thank you. Okay. And Mr. Griffith, you are the CEO of the debtor, is that correct?
That is correct.
Okay. And how long have you held that position?
Since inception, when the corporation was formed in 2008.
Okay. And I've asked your counsel to put before you the petition and schedules, which was docket number 1, which was filed on June 28th. Some superseding amendments, which is docket number 11, that was filed on July 12th. And additional amendments that were filed docket number 31 on July 31st.
Mm-hmm.
Do you have those in front of you?
Mm-hmm.
Yes.
Okay. And so what I'm going to ask you is, did you sign those documents under penalty of perjury?
I did.
Okay. And before you signed them, did you review them carefully?
Yes.
Okay. And to the best of your knowledge, is the information contained in these documents true and correct?
That is correct.
Okay. Ms. Villalobos, are there any amendments that further need to be made to the already existing schedules and amendments?
Yes.
Okay. What are those amendments?
We're still working on the creditor listing to finalize the secured creditor list.
I'm sorry, when you say creditor listing, which...
Schedule D.
Schedule D. It needs further amendments?
Yes.
Okay, so let's start our list of amendments, and I'll just put that as number 1, okay?
Okay, got it on my list.
And more specifically, obviously you put BDD on there, which is a secured lender, and another lender, I saw 2. What are you talking about when you say further amendments?
It's come to my attention last week that Maxim is further collateralized, so I need to amend the schedules to reflect that.
So it's not more creditors,
No
but
more creditors.
but a different...
The details of the listing.
Okay. For purposes of cash collateral, I didn't see, were they served with the cash collateral?
They
motion?
were served, and counsel has reached out to me, so we're working on a stipulation for them as well.
Okay. Okay. I checked the docket this morning. I did not see that there was a Federal Rule of Bankruptcy Procedure 2015.3 form filed. Was that filed before the hearing today?
It was not filed before the hearing today because I got the budget in on Saturday in the afternoon, so I do have it printed here, but I have not yet filed it. I need to go back to the office to do that.
Okay, so...
And I do have a copy for you.
Well, but it's not filed with the court. I'm
No,
not
it's
gonna,
not, but
okay.
I will file it.
So let's put that down as document number 2. And to be clear, for academic regularity, that would apply to all entities which the debtor has a 20% or more interest. So it's not just Ultimate Franchises, but I noticed on the schedules there's another entity called Ultimate 2 or something.
So it's been filled out for 2 Ultimate Brands and then Ultimate Franchises.
Okay. And any other entities in which the debtor has a 20% or more interest. So it's not just wholly owned. If you look at the rule, it's 20% or more.
No,
so
I understand. Not that I'm aware of. I went through it with Mr. Griffiths last week.
Okay. Okay. All right, Mr. Griffith, I'd like to shift gears now and go over some corporate governance issues. What year was the debtor incorporated?
The debtor was incorporated, I believe it was August 2008.
Okay. And at that time, you were the 100% shareholder, correct?
No, there were 2 shareholders, myself and my co-founder, Ron Love.
Okay. How was that divided?
50-50 at the time.
Okay. Okay. Now, I'd like to direct your attention to docket number 1, page 12 of 50. Actually, page 11 of 50.
Which schedule are you looking at?
It's docket item number 1, so that would have been the initial petition
The
and
petition,
schedules.
yes.
And I'm specifically referencing the list of equity holders, which is on page 11 of 50. Okay. And Mr. Griffiths, I'd like to direct your attention to the entity that's listed on there. The call of the question here is list all the equity holders in the debtor, and you listed Griffiths Organization. Do you see that?
Yes.
Okay. So at the time this case was filed, was Griffiths Organization the sole shareholder of this entity?
No.
So why did you list only the Griffiths Organization?
It's one of the shareholders of the entity. There are a number of shareholders.
Right, and the question is to list all of them, not just one or two. So,
The answer is I don't know why only one would be.
okay, how much does Griffiths Organization have at this time as far as equity?
It's less than 5%.
Griffiths Organization is less than 5%?
Yes.
Okay, why don't you tell me who owns the debtor? What are the, break out the equity holders for me?
I don't understand the question.
Who are the shareholders of the company?
The shareholders in the company, there are a number of shareholders. There's Ron Love.
Okay, how much does Mr. Love have?
He has less than 5%.
Let's start off with who's the largest shareholder.
The largest shareholder would be myself and my wife,
In what entity is that held in?
personally.
So S&L Griffiths, that would be Scott and Loretta Griffiths. That's your wife, correct?
Yes, Scott and Loretta
Okay,
Griffiths.
what percentage do you own in the company together?
I don't have the cap table in front of me, so I don't know the details.
Let me help you out. More than 50% or less than 50%?
Personally, it's probably more than 50%.
More than 60%?
I don't think so.
So somewhere between 50 to 60%?
I think so.
Okay. What about Lisa Liu?
Lisa Liu owns preferred shares and common, and she's less than 6%.
Okay. What about Dave Carpenter?
Dave Carpenter has preferred and common, and I think in the aggregate he is around 10 to 12%.
Okay, so I got 12, 18, 23. I'm still missing like 17% of the shareholders. Okay, so here's what I need you to do. Please amend the list of equity holders. So that we know who owns this company, okay?
Got it.
All right, let's move on. Mr. Griffith, who are the current directors of the corporation?
The current directors are my wife and myself.
Okay. I'd like to talk a little bit about the business model. Okay. According to the status report that was filed with the court on July 24th, which is docket number 24, the debtor owns and operates 5 men's hair salons under the name 1818 Salons. Is that correct?
1885 men's salons.
Okay, fine. The word fine. Okay. Fine men's. And the status report also reflects that the debtor has 2 sources of revenue. One, it receives franchisee royalties from 49 franchisee locations. Is that correct?
That is correct.
Okay. And 2, it has company-owned stores. Is that correct?
It has company-owned stores, and then it's managing, in the franchise organization, it manages several franchise
Okay,
stores as well.
so let's make a distinction. The status report specifically says there's 5 company-owned and
That
operated.
is correct.
Okay. In addition to the 5 company-owned and operated, how many does it manage?
It currently manages 2 others.
Okay. So when you say manage, how did that come about?
In the franchise agreement, if a franchisee is unable to manage for whatever reason, they have the right, or we have the right, to step in and manage the location, but we're not an owner of the location.
Okay, so when you do that, who pays the rent?
It depends. Sometimes the rent is deferred. Sometimes the franchisee still has rent obligation.
When you say
and sometimes
deferred, are you
rent.
saying the landlord defers it, or that you just
The
decide not?
landlord will talk to the landlord and ask for accommodation. The objective is to find a new franchise owner rather than us owning the store. So we prefer not to be on the lease and we prefer to basically flip it to a new owner.
Okay. So just to be clear, we got 5 company-owned stores, 2 others that you're managing pursuant to some sort of franchise situation where either you got into some kind of dispute with the franchisee, and then you have the royalties from the 49 franchisee locations. So let me ask you this question. On your cash collateral budget, which was filed with the court, okay, which is docket number 28, page 2 of 9. Okay, the budget talks about 9 salons. Why do you have 9 salons on the cash collateral budget, but you just testified that at most there's 7 salons in which you're controlling?
Okay, 5 are corporate,
Yes.
2 are under management,
Yeah.
and 2 we recently turned back to the franchisee. We essentially walked away for a number of issues. There were bank issues, there were landlord issues, and so we informed the landlords as well as the franchisee that we would no longer manage
Okay.
those locations.
So this budget at page 2 of 9, which references 9 salons, that's not correct. It should be 7 salons, right?
It just changed, I think, as of last Thursday or Friday, so it's a recent.
I understand. This is not a trick quiz. I'm just asking you whether this needs to be changed.
Yes, it needs to be changed.
Okay, so the revenue on here, which would reflect revenue from 9 salons, is really for 7 salons, correct?
That is correct.
Okay, now let's talk a little bit about Ultimate Franchises, Inc. Okay, so the debtor owns 100% of that company, which is called Ultimate Franchises, Inc., correct?
Yes,
And that company was formed in 2009, correct?
correct.
Okay, and the purpose of forming, I'm just going to call it UFI.
Okay.
Okay, was to act as the franchisor for the 1818, let me make sure I say it correctly, Fine Men's Salons brand, correct?
Correct.
And in fact, UFI entered into written franchise agreements with all of the current and former franchisees, correct?
The current and former franchisees is correct.
Okay. And those agreements, generally speaking, provide for an 8% royalty fee to be paid to UFI, correct?
It's 7% royalty, 1% marketing fee.
I understand. I'm just in
Okay.
aggregate.
In the aggregate, that is correct.
Okay. And those royalties are collected by way of electronic transfer from the franchisees' bank accounts under an HCH agreement they signed allowing UFI to hit their bank accounts, correct?
That's right.
Okay. And in fact, the debtor, Ultimate Brands, Inc., has never entered into any written franchise agreements with franchisees. Is that correct?
Ultimate Brands,
Our debtor, Ultimate Brands, not UFI, has never entered into any written agreements directly with the franchisees.
Ultimate Brands does not have any of the franchise contracts. I believe that is correct.
Okay. Now, is there a written agreement between the debtor and UFI? I'm talking about before June 27th, but was there a written agreement in effect between the debtor and UFI which allowed for the debtor to receive a portion of the royalties which UFI collected?
There's agreements between UFI and Ultimate Brands for royalties to be shared with Ultimate Brands for various operating purposes.
I'm talking about before June 27th, before the assignment that took place on the day before the filing.
It has existed since inception.
Okay, so there was a written agreement between UFI and UBI, and you have a copy of that agreement?
I'd have to find it. I'd have to go into the files.
Okay, and that agreement was drafted back in 2009 when UFI was formed?
Again, I have to go back. I don't know the exact date because we didn't start franchising until 2011.
Okay, so what was the allocation on the royalties? How much of the royalties would UBI participate in?
There wasn't a formula. There wasn't a specific formula. There's just an allowance that royalties can be shared from UFI with Ultimate Brands as the parent company. So there is, in the consolidated financials, it will show funds moving back and forth between the two entities.
Was it common for the entities to move monies back and forth?
Yes.
Okay. And was that pursuant to the agreement, or is that just the way things went?
Well, it's in agreements, but the agreements are not long legal contracts. It's just noted in various agreements over the years. Or I have to go back into the files.
Was there an accounting that was kept between the two entities?
Yes, our CPA of various accounts over the years have kept track of the intercompany exchanges.
Okay. Now let's shift to the eve of filing assignment from UFI to UBI. So on June 27th, 2019, the day before this case was filed, UFI assigned its rights to the franchisee's royalties to the debtor. Is that correct?
Yes.
Okay. Why did you do this?
Well, as I understand it, we need to, on a consolidated basis, make sure that everything is rolled up into a single entity. Since Ultimate Franchises is 100% owned by Ultimate Brands, and to the benefit of the creditors, everything needs to be consolidated to the benefit of the creditors.
So how did assigning the rights from UFI to UBI benefit the creditors?
Because you have royalties and contracts that benefit the creditors as assets.
Okay, what about the creditors of UFI?
The only creditor of UFI is Ultimate Brands.
Okay, so you're saying UFI has never been sued?
UFI has been sued, but it is a wholly owned subsidiary of Ultimate Brands.
Okay, I'm going to try this again. Is there any pending litigation against UFI?
There's pending litigation against UFI.
Okay, you understand those are, at a minimum, contingent unliquidated creditors, meaning that while their claim hasn't been resolved, they're creditors of that company.
I understand that they're creditors of that company and the claims have not been resolved.
Okay. So how did moving the royalty stream from UFI to UBI benefit those creditors?
Well, I understand through my counsel that the assets all need to exist to the benefit of, since Ultimate Brands is ultimately the, and I'm not a lawyer and I'm not an expert in finance on these type of matters, but my understanding is everything has been represented on a consolidated basis historically, and Ultimate Brands owns 100% of Ultimate Franchises. So my understanding is that all the assets need to exist to the benefit of the creditors of Ultimate Brands, which owns Ultimate Franchises 100%.
And that was on the advice of counsel?
And we have an expert who has been through.
Answer my question. That was on the advice of counsel?
I don't recall.
Ms. Villalobos, were you involved in the transaction of assigning the rights from UFI to UBI?
No.
Okay. Do you know who was?
No.
Do you know if there was a lawyer who did assist in the transaction?
I'm unsure. I do not know.
Do you know, Mr. Griffiths?
I have a financial advisor, and that's the advice that I was given by the financial advisor.
So it wasn't a lawyer, but it was a financial advisor.
That is correct.
Is it the same financial advisor that you're seeking to employ in this case?
Seeking to what?
Employ in this case?
Yes, it is.
And he's the one who told you that you needed to move all of the franchisee royalties from UFI to UBI?
In his opinion, everything needs to be on a consolidated basis to the benefit of Ultimate Brands.
Okay, and remind me, his name is Mr. Guadano, is that correct?
Madonna, yeah. Brian.
Is he here today?
He is not. His wife is about to deliver a baby.
Okay, and where does he live?
He lives in Austin, Texas.
Okay. Now, why are you hiring a financial advisor from Austin, Texas to handle a case that's in California?
We've been, prior to the BK filing, we've been actively pursuing investors. and Will Churchwad, who's an M&A attorney, introduced us to Brian and his team. And at the time, we were looking to secure outside investors, and Brian was talking to a number of investment groups. Do you mind if I take some water real quick?
Oh, absolutely. Yeah.
And Brian, very respected, highly recommended, who's been through a number of these, for franchisors, a number of these issues before, said that because of the pending litigation, as well as some of the other outstanding issues, that the valuation would be problematic, and that we really needed to look at doing a restructuring of the company in order to clear everything, essentially get a fresh start, so that we could revisit various investor groups.
When you say the valuation would be difficult, valuation of what entity?
Well, we've always looked at Ultimate Brands, again, on a consolidated basis. So we look at the whole basket. We're not looking to have investor come in piecemeal. When they invest in Ultimate Brands, they're investing in all of it. And so our objective was to reduce the pressures that have been plaguing us for well over a year, and get to a point where we essentially have a fresh start. We can recapitalize the company and move forward.
Okay. Ms. Field, I'm going to ask you this question. Is there written documentation evidencing the assignment of the royalties from UFI to UBI?
I have not seen it.
Okay. Mr. Griffiths, are you aware of any such documentation?
I believe it exists, and again, I have to go back into my files.
Okay, but we're talking about a transaction that took place on June 27th, so we're not talking ancient history here.
There have been so many moving parts, I have to go back into my notes and see what officially was.
You said Mr. Guadana was assisting you with that transaction, at least advising you with
No,
transaction.
he advised.
Okay. Who actually prepared the paperwork?
I would prepare the paperwork.
You prepared the paperwork for the assignment of royalties from UFI to UBI?
Yeah, I would have just a formal memo acknowledging that was something that had been discussed, and as essentially the board would authorize the transaction.
Have you ever drafted a legal document assigning rights from one entity to another?
Yes, I have. As an entrepreneur, I've done simple documents.
Okay.
More as memorandums as opposed to complex legal documents.
So Ms. Villalobos has asked you for the document and you haven't been able to locate it yet?
She hasn't asked for it, and I haven't.
Well, I know we've asked her for it. And I know she's pretty diligent, so I assume she asked you for it.
I have to apologize. So many moving parts, and I know that sounds like an excuse, but...
No, I'm just trying to understand what's going on here.
Yeah.
Okay. Now, so you transferred the royalty stream. That pretty much was the only asset UFI had, correct?
No, the stores are on the balance sheet as assets as well.
What do you mean the stores?
The stores that we have leases and that we own, because the resale value...
Lois, slow down. UFI is the franchisor. Okay? It has written agreements with franchisees.
That is correct.
Okay? And so the assets are those written agreements which provide a royalty stream to UFI. What other assets other than those franchisee agreements does UFI have?
I thought you were talking about Ultimate Brands as well.
I'm talking UFI is a separate, distinct legal
I understand.
entity. Okay. Other than that royalty stream, which is derived from the franchisee agreements, what other asset or assets does UFI have?
None.
Okay, that's what. So when UFI gave all of its assets to UBI, what did UFI receive in exchange?
I don't know how to answer that question because it's a 100% wholly owned subsidiary, so there's no...
Well, I'll help you. Did UBI pay UFI any
No.
money? Okay, so there's no funds exchange, correct?
Correct.
Okay. Okay. Was there any other type of remuneration or compensation?
No.
Okay. So it's fair to say they received nothing. Is that correct?
That is correct.
Okay. Okay. I want to shift gears for a second here and talk about debtor's business premises and where it does business. The bankruptcy documents reflect that the debtor's place of business is 30821 Seminole Laguna Niguel. Is that correct?
Currently, we gave up our office.
Okay. When did you give up the office?
I lose track of time.
Well, let's just go for a month. Was it in this year?
It was the end of 2018.
Okay, so this is your personal residence, correct?
That is correct.
Okay. So where do you go when you have a staff meeting?
Well, we work virtually. We have managers in Minnesota and Cincinnati, Irvine. So we typically have conference calls, a Zoom meeting or a teleconference. Sometimes we'll meet at the house with various individuals. Sometimes we'll meet at a Starbucks.
Okay. Now, on the 5 company-owned stores, is the debtor named as the lessee on those leases?
It should be. I didn't look at. I got copies of all the leases, which I shared with counsel.
Okay. And are you personally on liable for?
No.
Okay. Anyone else personally on the hook?
No.
Okay. Let's go over the employees. The debtor has approximately 58 W-2 employees. Is that correct?
That sounds about correct.
Approximately. Okay. Okay. And about 8 of those are at, we'll just call it the corporate level, as opposed to working in the salons. Is that correct?
That sounds about right.
So we'll call those the virtual corporate headquarters employees? Okay. And you said they're spread around the country?
Yes.
So give me, how many are in California and how many are not in California?
Well, you got one in Cincinnati, you got one in Minnesota, and the rest are in Southern California.
Okay, so we got 6 in California. And that includes you and your wife?
We didn't show ourselves as W-2 employees on that list.
Okay. Okay. So
no.
So that'd be no. So you list yourselves as what kind of employees? 1099?
We've paid, when there's been cash, we've paid ourselves on a 1099 through our personal corporation, which is the Griffiths organization.
So number 1, you pay yourself as 1099 employees, and 2, when you say you mean you pay it through the Griffiths organization?
We pay to the Griffiths organization.
Okay. And what is the Griffiths organization?
It's a wholly owned, 100% owned by my wife and myself.
And what is its purpose?
Originally, its purpose was I ran a branding consulting business for many years, and that went dormant when I devoted myself full-time to the current business.
Okay. So we have 8 virtual, 8 W-2 employees at the virtual corporate headquarters. That does not include you and your wife. Does your wife still work for the company?
Yes.
And what does she do?
She's the glue. She interfaces with...
What's her skill set besides being glue?
I was about to describe that.
Yeah.
She interfaces with what used to be the front desk on the shipping of all the products to all the salons. She interfaces with operations. She makes sure that licenses for the stores, cosmetology license, are taken care of, sales tax licenses. She interfaces with marketing to get various collateral pieces produced. The collateral is online, accessible online by the franchisees. She's the girl Friday if something needs to get done.
What is her background?
Her background is as office administrator. She has a design degree, interior design degree from UCLA, a graphics background. In all our businesses over the years, she's She's essentially been the office manager administrator in multiple businesses, as well as managing much of the design and interfacing with design and marketing.
Okay. And, okay, let's shift over to the 50 W-2 employees at the salons.
Yes.
So just break those down as far as functions. We got people with stylists.
You have two basic functions.
Yeah.
You have a front desk function. We call not receptionists, we call them DOFIs, directors of first impression. And we have, in terms of the services, you have two licenses. You have a cosmetology license, stylist, and you have a barber license, barber.
Okay, so just the bottom line, you have people who cut the hair, and you have people who, greet the people, line them up, and that kind of thing.
That is correct.
Okay, and there's 50 of those people spread out amongst, I think we're now down to 7 stores, is that correct?
We're down to 7 stores, and so the number changes. The employees are added and reduced literally on a weekly basis, so
Okay.
to be between 45 and 55.
Okay, so
is
we've
the
now
range.
covered where the 58 employees are, W-2 plus you and your wife. How many 1099 employees are there other than you and your wife?
Andrew in Minnesota has been on a 1099, and he's helping to lead operations, working with Bridget. Chris Brown has,
Okay, I don't know, Chris, but just give me a number before we start going into names.
okay, sorry.
Order of magnitude, more than 5, less than 5?
Separate from my wife and myself,
Separate from you and your wife.
5.
Okay, about 5. Okay. And there's people like Chris and Andrew, and they live all over the country, and what do they do?
Okay. Andrew owns 2 salons as a franchisee. He has a Navy background. He has a...
No, but what does he do for the company?
Okay. He is leading at a senior level our operations, as well as a new initiative called True Solutions for Thinning Hair.
And there's 4 other people like him who are doing various different functions for the company.
Yes, you have a creative director, Jerry Gomez. You have accounting, which is Cynthia. You have bookkeeping, which is Aaron. You have Chris Brown, which is marketing development.
And why are they 1099 employees?
Because they're outside entities. Chris Brown is not an employee. He has the salons that he runs. He works part-time. We don't set his hours. He's functioning on a consultant basis. Andrew is functioning on a consultant basis. Cynthia has her own accounting firm. Aaron has her own bookkeeping firm. Jerry has his own creative advertising firm.
Let's move on. Are either you and your wife have either you and your wife been paid since the inception of this case?
No.
Are you and your wife going to seek to be paid?
Yes.
Okay. And Ms. Villalobos, I'm going to ask you this. Looking at the cash collateral budget at document 28, is their salary or their 1099, I should say, is that included under the line item that says salon 1099 W-2 or corporate 1099 consulting?
No,
Well, is it in the budget?
it's not in the budget.
Okay, well, if they're seeking compensation and it's not in the budget, how's that going to work?
Eventually, he'd like to see compensation. We haven't filed the amended notice of insider comp at this point.
Okay.
It's not right now.
Okay, so Mr. Griffiths, you and your wife understand that until your attorney goes through a certain procedure, that you can't take any kind of compensation, whether it's in the form of 1099 or W-2 or any kind of distributions from the company.
We understand that.
Okay. So, Ms. Villalobos, just for clarification, within this budget, you're saying that the insider compensation is not yet included in it?
It's not included.
Can I consult with my counsel?
Yep. You want to step outside? You
Well,
want?
I can just whisper in her
Yeah,
ear,
go
that's
ahead.
fine. I understand. Thank you.
Okay. And just to put a finer point on it, that would include any payments to any entities which you control. So that could be anything from Griffiths Organization to Great Griffiths to any other entities which I don't even know about. Do you understand that?
I understand.
Okay. Let's talk a little bit about taxes. So we just discussed that the debtor currently has about 58 W-2 employees, about 5 1099 employees, and then you and your wife. So that's now. I want to go back in time a little bit. Calendar year 2017, how many W-2 employees did the debtor have?
I don't know.
Okay, and why would you not know that?
Because HR handles all the payroll, and I'm typically not involved in the details of the payroll.
So you're telling me, as we sit here today, you had no idea how many employees you had?
No, I have an idea, but you're asking for a number. It typically...
Well, let me keep it simple. Is it more than what you have now on the W-2 level, or less?
It averages about 8 to 10 per salon is the formula.
Okay, so did you have more salons then, or less?
And what date were you referring to?
Calendar year 2017.
I believe we had 5 salons in calendar year 17.
Okay, so the numbers should be about the same as far as W-2 employees.
I believe so.
Okay. What about the number of 1099 employees? Was it about the same?
In that year?
Yeah, 2017.
It would have been less.
So currently we're at the 5 plus you and your wife is 7, so you're saying it was less than 7?
It was 2 less.
Okay, so about 5. So now let's go to calendar year 2018, okay? Why didn't you file your payroll tax returns, when I say you, I'm talking about the debtor, for calendar year, all of calendar year 2018?
I don't know. That's our outside accounting firm. Cynthia handles all the...
Who's Cynthia?
Cynthia...
What's her last name? Cynthia Diaz?
Diaz, yes, sorry.
No, she's in the papers. Okay. So Cynthia Diaz, who's listed as one of the people who's in control of the documents of the company, what's exactly her professional background?
She has a distinguished background as a CPA.
Okay, so she's a CPA, and you have not discussed with her why she hasn't filed the payroll tax returns for all of calendar year 2018.
I know that we had an outside payroll service.
Who was that?
We had.
Who was that?
It was Avitus.
Say that again?
Avitus, A-V-I-T-U-S. Okay, and Avitus handled all the payroll services, including the filings. And before that, we had ADP.
Okay. When did the relationship with Avitus end?
It ended in, and I don't remember the exact date, but it was sometime in 2018.
Okay, so I'm going to just come back to the simple question. Why didn't the debtor, other than, I mean, if the answer is you don't know, but why didn't the debtor file payroll tax returns for all of calendar year 2018?
I don't know. I can only speculate, which I probably shouldn't do.
Okay. Now, and why has the debtor not filed payroll tax returns for all of this year?
I can only speculate what I think the reason is, but you're asking for a specific answer, and we'd have to consult with Cynthia.
Okay. Now, the IRS has filed a document under penalty of perjury with this court on July 29th. It's proof of claim 1-1. And what they're saying in that document is what I just said, which is that for all of 2018, they haven't received any payroll tax returns, nor have they for all of 2019. And based upon that, they've estimated that the debtor owes $663,000 of taxes, plus a little bit of interest.
Mhm.
Have you seen this document?
No, I have not.
Ms. Villalobos, have you seen the document?
I've seen the document, yes, but I don't have a copy with me. I just have the IRS letter.
Okay. So let's start with calendar year 2019. Has the debtor paid any payroll taxes in 2019?
No.
Now, just to be clear, we're talking about both IRS and Franchise Tax Board, both state and federal?
I don't know with certainty.
Okay, but you know the IRS hasn't been paid?
I know we owe taxes, and I suspect we owe taxes both on payroll as well. Well, we don't owe any federal taxes because
Okay, let's
We don't
stop
have
for a
any.
second. I asked you a simple question. I said, in calendar year 2019, have you made any payments on your payroll taxes? And you emphatically said no.
emphatically that is correct.
Okay, so, okay. And then I tried to make a distinction between federal and state, and we kind of got off on the side here. So you've paid no federal payroll taxes, correct?
Not that I know of.
Okay, and would it be true for the state as well?
I believe that it would be correct.
Okay. Okay, let's go back to calendar year 2018. Is it also true that there were no payroll taxes paid in calendar year 2018?
That is not correct.
Okay. Was there some portion of the payroll taxes that were not paid?
That is correct. It
Okay.
was paid.
Well, tell me which portion was not paid.
Well, federal and state was paid up until the time the relationship with Avitas was terminated, which I believe was around the middle of 2018.
Okay, so it's your position that at least from, June of 2018 through the end of the year, that there was no payroll taxes made?
That's my best guess.
Okay. Were you aware that the IRS was asserting that they were owed $663,000?
No.
Okay.
And I don't believe if that is correct. But
Okay.
based on conversations I've had with our finance department.
Okay. And this is the same finance department that hasn't filed payroll taxes for the last year and a half?
Yes.
Okay, just want to make sure you're solid on that. Let's talk about workers' comp for a bit. You remember coming to this building? Today's not the first time you've been in this building, right?
I've never been here before.
You've never been here before? Really?
Our IDI was at a Pete's Coffee.
Okay, got it. Okay. You ever been to Pete's Coffee?
I think their stock has gone up 10% because of me.
Okay, and did you meet with that woman who's sitting in the back? She's with our office. Her name
Yeah,
is
she's a nice lady, Marilyn, I believe.
Yeah,
is her
I'm
name.
the bad cop.
Yeah, you're the bad guy.
Okay, so you recall meeting with her, not in this building, but at Pete's Coffee, or
She wanted to see one of the locations, so we did meet at a location, and it's within a shopping center, so we decided to hold the IDI.
And at that meeting, the purpose of it was to discuss this case, correct?
Yes.
Okay. And you told Ms. Sorensen, that's the woman I'm pointing to in the back, at that meeting, that the debtor did not have workers' compensation insurance.
What I said is Ultimate Brands did not have workers' comp. We were covering payroll through one of the
Okay,
other
let's step back from
entities.
that. The debtor is Ultimate Brands, okay? There's no other entity in
The
bankruptcy.
debtor has not done payroll directly, and so it didn't have the workers' comp. We were told to get workers' comp for Ultimate Brands, which has now been secured through the insurance
Let's
agency.
just go back a second. When you had that meeting on July 15th, did the debtor, Ultimate Brands, have workers' compensation insurance?
No.
Okay. And in fact, I think you told Ms. Sorensen that it actually, there was a policy, but it actually expired 6 to 9 months ago. Is that correct?
When we were with Avitas, the workers' comp was provided through Avitas for all the payroll.
Right, but Avitas has been out of the picture since a year, for a year now.
I don't know the exact period that we terminated Avitas. I think it could have been September.
Okay, but let's say September. Okay. So when Avitas exited the picture, the debtor no longer had workers' compensation insurance. Is that correct?
The debtor did not have workers' comp we made adjustments, but the answer to your question is the debtor, Ultimate Brands, did not have workers' comp, but it didn't need it. So,
What do you mean it didn't need it?
because we weren't running payroll through Ultimate Brands.
So it's your position that if you use a third-party payroll service, that you're relieved from your responsibility of maintaining workers' compensation
No, we
insurance?
had workers' comp, but we had it to cover the third-party entity that was making the payroll.
What do you mean to cover the third-party entity? What about the 58 employees that work for you?
The employees, we were not showing them as employees of Ultimate Brands, we were showing them as employees of Ultimate Franchises. So, and we use a third party to provide the workers' comp. So it was a little bit complex.
Well, it's not really that complex. You just testified that you have employees that you pay as employees of Ultimate Brands.
I'm sorry, on a consolidated basis, we're showing them employees of the whole entity. So, so they work for Ultimate Brands, but they were being paid out of one of the other entities.
Let me ask you this question. As we sit here today, have you obtained workers' compensation insurance for the employees of Ultimate Brands, Inc., the 58 W-2 employees?
The answer is yes.
Okay. Do you have proof of that?
Yes.
This is the proposal that was solidified over the weekend.
So this says it's a proposal. I'm looking for some sort of declaration, writer, or something that shows that you're actually insured.
I believe that's in my email as of this morning, but as over the weekend, this is what was.
But this is just a proposal, right?
Yes.
Okay. Well, I'm
We
going to give you
signed
back
it
the
on
proposal.
Friday, and then we
Okay.
funded it over the weekend.
Okay.
Well, he funded it over the weekend.
So when are you going to share that document with us?
When are you going to have the work comp declaration back from Cameron?
I'll call them right after the meeting and get that information to you, Julie.
Thank you.
So as we sit here today, you do not have from the entity you're dealing with a completed, executed document that says that the workers' comp is in place.
We signed, when did we meet? We met on
Friday.
Friday. So we signed the proposal on Friday and asked Cameron to bind as of the date we signed the proposal. So,
But you understand the difference between a proposal and having a document that
but
says...
once we sign it, then he immediately binds. So I assume that it's been bound. So I'll have to follow up with Cameron, who's our insurance broker, to get a copy of the actual document.
Okay, well... Give me a second. All right. So you just testified that you met over the weekend and you signed some document on Friday, and we're probably going to get something today or tomorrow or whatever. But on July 31st of this year, you filed a declaration in support of an opposition, which is docket number 34, to our motion. And at paragraph 6, which is at page 4 of 10, you state that on July 25th, 2019, debtor admitted the current Hanover insurance policy to the oust, which includes its current workers' compensation provision. I'm going to show this to you.
I have it here.
Okay. So explain to me how on July 31st you took the position that the debtor was already covered by Hanover Insurance and the workers' compensation situation was resolved, when in fact it wasn't.
No, I don't know where the confusion is.
Well, why don't you read that, pick up that document, and look at paragraph 6 and read the sentence at line 20 to me that starts with, into the record, on July 25th. Just read that out loud.
Yes,
Just read it into the record.
I'm going to read it. Debtor's failure to maintain worker compensation. On July 25th, debtor remitted the current Hanover insurance policy to the OUST, which includes its current workers' compensation provision.
Okay. Is that true?
This is not accurate.
Okay.
The workers' comp is through Travelers. Hanover is general liability.
You realize, so we have an analyst who's got to go through all this paperwork, okay? And there was like a 200-page document that was given to her where she had to scrub through it. And so you realize how difficult it is to administer a case like this when just about everything is riddled with inaccuracies.
I understand your frustration that you're expressing, and all I can do is apologize.
Well, it's much more than apologizing to me. It's the creditors who are affected. Okay,
of which I'm the largest creditor, by the way.
Okay. Whether that's true or not, I don't know. I mean, obviously your schedule, but here's the point. When you file for bankruptcy, your legal position changes. So I don't know if that's been explained to you, but I'm going to explain it to you. You become a fiduciary to your creditors. That's a relationship that doesn't necessarily exist before the filing, but it certainly exists once you file for bankruptcy. Okay? And as a fiduciary, you have a responsibility to do things. One of the core things to do is to follow the bankruptcy rules and the bankruptcy code. And that requires filing documents under penalty of perjury that are accurate. Okay? And it requires complying with things that our office requests so that when people ask us for it, we can give them that information because they're entitled to it.
Right.
Okay. So you're supposed to be a fiduciary in all aspects of the case. Okay? And that's my point here, is that there was a statement made under penalty of perjury that simply was not true. Okay? And there's been many, many of those throughout these documents that are not accurate. And that makes it very difficult to oversee a case to the point where we may not want you to be a fiduciary anymore. Do you understand that?
I understand how serious of an issue it is, and I don't want to make any excuses. I can see where mistakes were made, but there's been no ill intent whatsoever.
Well, it's not even ill intent. You could simply just not be up to the task. There's ill intent is not required. If you run a extremely sloppy, or you don't understand the difference between one entity and another, and you move monies back and forth, and on the eve of filing you just happen to upstream the entire assets of another company, you may have no ill motives at all, but you just may be running amok. And that in and of itself is a basis for you to no longer be the fiduciary of this entity during this bankruptcy case. So there's no ill intent required.
I'm up to the task. I've been able to get my arms around all the details over the last 2 weeks. I can see where certain issues arose. There's been complexity. The insurance issue is purely a mistake because there were two policies. Travelers was the workers' comp, Hanover was the general liability, and in our filing that was simply missed. But it wasn't that we didn't have workers' comp, and when we were requested to specifically have workers' comp for Ultimate Brands, a proposal was provided by our broker. It was signed, and it should have been bound as soon as that was faxed back on Friday, and we'll get a copy of that workers' comp for you.
But that's not what happened. What happened is there was a declaration put already before the court that says you have workers' comp, and in fact you had to meet later on that week to actually get the workers' comp. So this is a highly, at best, highly misleading statement.
I understood that the workers' comp that we had at the time covering the payroll was sufficient. Our advisor, Brian, said you have to get workers' comp under Ultimate Brands. So when it was made clear to me that that was a requirement, then we proceeded in earnest to wrap that up. But we did have workers' comp, and it does cover our employees for the payroll that we've been making. But Ultimate Brands, as the entity that has filed, I was told has to have its own specific policy. And that has been secured, and we'll get the documentation on that.
Let's talk a little bit about intellectual property. Who owns the 1818 Fine Men's Salon name?
That trademark has been moved back into Ultimate Brands. It was inadvertently put into the name of my trust. I don't know all the details. Is that something, Julie, that I need to consult with you on?
Well, let me just ask questions. and
Very
then-
simply, Ultimate Brands owns the IP.
Okay, but at the 341 meeting, I'm sorry, at the IDI with Ms. Sorensen, you represented to her that there's an entity called S&L Trust, which obviously is your first name and your wife's first name, that was formed in 2015, correct? And that the brand name 1818 Fine Men Salon was held by that trust. Is that correct?
I said that to Marilyn, yes.
Okay, so that was on July 15th. What happened between July 15th and today such that that trademark is now moved back to 1818, to the debtor?
Our franchise attorney, we have a separate brand called Griffiths, which I own 100%. It's completely independent of everything that is part of our discussions. Our franchise attorney was confused when we set up the trademark under the trust. It should have only been for Griffiths. 188 should have remained under the ownership of Ultimate Brands, and that is where the ownership is. It's under Ultimate Brands.
Is there any documentation evidencing the transfer of the trademark name from the trust to the debtor?
I'd have to consult with our advisors and.
Ms. Villalobos, are you aware of any such
I have
documentation?
not seen any documentation.
Were you aware that the trademark was moved from, after the July 15th meeting, were you made aware that the trademark name was moved from the S&L Trust to the debtor?
It's my understanding that no movement has been made. I personally advise Scott that that trademark belongs to Ultimate Brands and needs to be within the estate.
But you were at the IDI when he said that the S&L Trust.
Yeah, so what I'm saying is it has not officially been moved. I haven't seen it. I haven't seen whether it's even held in the trust name. I'm seeking the franchise attorney contact information to unwind the transfer. But I've not seen any documentation as to who owns it. My opinion is Ultimate Brands should carry that asset, which I've advised Scott.
Okay. Let me ask you another question. Why was this case filed?
The case was filed because the dominant reason was that our contracts are very strong. We use the best franchise attorney, Leslie Pajot, who works with Plave Cook.
No, I asked you why the case was filed.
It was filed because we had litigation that was costing us time and money and compromising our ability to raise capital. We also had a claim from Mr. Carpenter, who acquired a loan from the bank, and Mr. Carpenter wants that loan to be paid back. So the combination of the litigation as well as the loan being paid back to Mr. Carpenter created a situation, and our ability to raise capital was compromised because despite our efforts to try to reconcile with all parties, we were not able, and it was dragging on and taking resources away from the company and limiting our ability to raise capital to finance operations and growth.
Okay, let's just try and put this in boxes here. So 660 BVD, which is a successor to the Santa Barbara Community Bank loan, they were suing both the debtor and you personally, correct?
That is correct.
Okay. Let's just go down. What else was either in form of litigation or other reason why you filed this case?
You have ex-franchisee litigation, or franchisees that, I don't want to try the case with you, but you have franchisees that hired contingency lawyers and were suing us to try to get resources from the company.
Okay, so we have the 660 BVD litigation, franchisee litigation. What else?
That was several lawsuits.
Right. I've read the paper.
And then we have other debtors. We have Maxim. We have a credit card. We have Go Financial, GoFin, financial that's on a residual amount.
Were you receiving any notices personally from the IRS about the trust fund taxes that weren't being paid?
Yeah, we knew that we owed money for payroll taxes. And
What about any hard money lenders?
well, we had a merchant cash advance. Would you consider that a hard money lender?
I consider a hard money corporate lender or where there's astronomical rates. You sign an ACH agreement, they can hit your account.
Yes.
Okay, that's the type of
Yeah.
typical thing we see.
That's
Happy Rock.
Happy Rock is they go by the name of GoFin and Happy Rock.
There's,
So
there's dozens of there are hundreds of them. They're all
Yes.
over the place now.
yes, we have one of those that is lingering.
Okay, so Ms. Villalobos, were you aware of any other reasons? We got the BVD, franchisee litigation, IRS taxes, hard money loans.
That's as far as I was aware.
Was there something imminent that was happening? Like, was there like an arbitration or something that was happening?
Yeah, we had an arbitration that I think most of it we could have resolved, but we had one that was very aggressive, and we just could not find any settlement option.
Okay, I'd like to go over the cash collateral budget now with you. It's docket item number 28, page 2 of 9.
Sorry, this is the wrong thing. This is
Do you have page 2 of 9 in front of you, sir?
Is that with the heading of 85811? It's numerals 2 through 8?
Well, we're looking at docket item 28, page 2 of 9.
Okay. I believe we have it.
So this should be,
Should be it. Yeah, it's there.
Right.
okay,
Thank you.
all right. First of all, who prepared this budget?
I gave my worksheets to Brian Guadano, and Brian Guadano took my notes, and then working with accounting, prepared this document here.
So it's you, Guadano. When you say accounting, who's accounting?
Cynthia.
Cynthia and the bookkeeper, Aaron.
Okay. And did you review the document before it was filed with the court?
I've seen various iterations of this. I don't know if I've seen this final iteration.
But you reviewed drafts of it.
I've reviewed drafts.
Okay. So let's just looking at the top line item, the revenue, okay? There's two sources of funds, corporate store revenues and royalties. Starting with the corporate store revenues, is that based upon 9 stores, 7 stores, 5 stores?
The latest iteration should have reduced it down to the 7 stores.
Okay. So this needs to be amended then, correct? This is not...
Can I ask him a quick question?
Sure.
As of the date of this budget, when we filed it with the court, Scott, were you receiving revenues from those 2 stores that have been closed?
We were receiving revenues from those 2 stores that have been closed. So there's 2 components. It was bleeding cash, so we had the expenses and we had the revenues. So that the net cash flow would have gone up as a
Well,
result.
that's not what I'm trying to hear. Okay. If you look at the actual budget, and if you look at where it says salon, it says stylist, barber's, front desk, it says 9 salons. So what I'm asking you is, does the revenue line item reflect 9 salons or 7 salons?
If it wasn't amended in the last week, it would reflect
It
9.
reflects 9.
Okay. So cash collateral budget
I already have it on my list.
needs to be revised to reflect only 7 stores. So it's fair to say that the top line item is not accurate. Although it says corporate store revenues, when you use that term in this budget, did you include the 4 stores? At that time when there was 9?
The budget, the total revenue would have included the corporate stores and the stores that are being managed.
Okay, so plus managed. So this revenue of, which is, the number is always 64,000 every week if you look at the line item, that number needs to be modified, correct?
Correct.
Okay, and let me ask you this question. As we sit here today, for the month of July, did the numbers come out to $64,000 a week for the month of July? Which would, if you do the math, let's call it 4 times 70, it's like $280,000 in revenue. Did you hit that number in July?
It would have been close. When this was put together, these were estimates, so we'd have to go back and fill with the actual numbers. So at the time, my notes were provided to Brian based on corporate stores and managed stores. Those were estimates based on, reasonable history.
Okay, but at a minimum, the numbers have to be modified going forward because of the reduction by 2 stores.
That is correct. Revenues will go down, and the payroll expenses will also go down.
Well, let me ask you this question. With respect to the, let me ask one more question. On the royalty line item, you show $75,000 a month. For the month of July, did the debtor actually receive $75,000 a month?
It was very close to that amount.
Okay. What's very close?
It would have been within 2,000 or 3,000.
So it was a little short?
No, I don't know. I don't know exactly what that final number was.
Okay.
Now, we have it on a cash basis, but you also have it on accrual, so we're showing it on a cash basis.
Well, a cash collateral budget, this is a cash-based budget.
Okay, then it would be close, but it's probably within 2,000 or 3,000. Also, when we put together the royalty numbers, it's assuming everybody's paying the royalties, and that no ACHs are going to be withheld or bounced.
Okay. Looking at the expense line items, the corporate 1099 consulting, who's included in that line item?
Included in that line item would be
Because
Chris Brown, it would be Cynthia, it would be Aaron, it would be Andrew, it would be Jerry, and
But there's no insiders in there, correct?
not me or my wife.
Okay, because that's a big number. That's $52,000 a month.
Yes.
52.7 to be exact.
Yes.
So
and that-
you're paying 5.
Well, on a go-forward basis, I included myself on a go-forward basis, but as of this date, I have not collected any compensation
I understand,
at all.
but does the $52,700 a month, does that include or not include?
That would have included me as well.
Okay, how much did you and your wife?
We haven't taken anything.
No, but in the $52,700 a month, how much of that is you and your wife?
We're including $20,000 a month for myself, and we're including $5,000 a month for Loretta.
So essentially half of that is you and your wife.
That is correct.
Okay. And what if you don't get that money?
Well, one, we haven't taken compensation for a long time.
No, I'm just asking you, what if you don't get that? What if the court doesn't approve it? What if we object and the court says we're not going to give you any money?
I have no other means of compensation since I have no other job. This has been my full-time job for a number of years.
Okay.
And I've been the lender of last resort.
Then you have the corporate W-2 line item, and that would be the 58 corporate W-2 employees?
Well, you have two.
I'm sorry, that would be the 6 the 6 corporate, right?
Yes, well, I think it was 8 was the number we discussed.
Okay, whether it's 8 or 6, okay, it's 8, okay. And then the salon, 1099, W-2 stylists, barbers, we talked about that.
Yeah.
But the 1099 in there, why do you have that in 2 different places?
The reason why is, for example, the stores in Texas that we closed, that we intended to sell, we would have them as 1099s because we don't intend to keep the store and have W-2 employees. So it's a transition method of compensation.
Okay. With respect to taxes and specifically payroll taxes, is the debtor current on its, well, there's a term we use called post-petition. This case was filed on June 28th of this year. Is the debtor current on its post-petition taxes and specifically payroll taxes?
No.
Okay, what is the delinquency?
How much?
Yeah.
Oh, my best guess is it's in the $10,000 to $15,000 range.
And that's just for payroll taxes?
Yes.
Okay. And with respect to rent, is the debtor current on, and to be clear, that $15,000 is for the period after the filing, correct?
That is correct. And in the cash collateral, we do show payments being made on the taxes. We've included in our
It's
cash flows.
estimated moving forward.
I understand. What about the rent? Are you current on your, did you make your July rent? You only have,
I think we've made half of the July rent. I think we're still behind on half of the July rent.
what about August?
Rents typically aren't due until the 6th or to the 10th of the month, so we
Okay.
haven't made the August rents yet.
Now, I want to make a distinction between on the rent between the corporate and the managed stores. On the managed stores, have you ever paid rent on those?
Yes, we haven't paid rent. We've made payments in good faith as we were seeking to secure a new owner. So we would negotiate with the landlords and explain the situation. And so we would cash flow the landlord at good faith, but we're not on the lease, so we're not obligated to pay rent.
What is the dollar amount on, you said you're behind on half of July's rent, so what would that come out to?
Well, Pasadena is paid. Lake Forest we owe July. Costa Mesa we owe. So the amount that we owe right now in rents is probably in the $15,000, $17,000 range.
Okay, so you owe post-petition rent of $15,000, you owe post-petition taxes of $15,000, is that correct?
10 to 15.
Okay, 10 to 15. Then I want to draw your attention. So if you look at your budget at page 2 of 9, about the middle of the page, there's a double line item. There's a double line called ending cash balance. Do you see that? It's got like 2 lines.
Yes.
Okay. And I want you to just kind of track that line. And I want to get to, let's say, week 6. Okay? When you get to week 6, which is called, okay, you see where it shows negative $22,855?
Yes.
Okay, so that shows me that at that point, you have no money in the bank. In fact, you have a negative balance of $22,855 on a cash basis. Okay, and then if you just keep tracking that all the way through the rest of the budget to week 14, it shows a negative balance of $139,735. Do you see that?
Yes.
Okay. Ms. Villalobos, did you review this before it was filed with the court?
I did.
Okay, how are you going to breach the $139,000?
There's a proposed DIP loan that's being finalized. I don't have the final document. I got the first draft also on last Friday. So I have a conference call after today's meeting with Brian and the DIP lender and another attorney in my office to try to finalize those terms to file a motion with the court.
Okay, so I'm trying to figure out, is this an arm's length DIP lender?
Yes.
Well, that's even more surprising. There's only two types of people that would make this DIP loan. One, if it's not arm's length, which sometimes friends or whatever will do that, or two, someone who has no idea what they're doing. So what's the name of this entity that's making this DIP loan?
I don't want to disclose it right now.
Okay, I don't, there's no one in their right mind that would make a DIP loan on this. I mean, first of all, they would have to seek to push down BVD on its first,
I understand.
which is priming lien. And in order to do priming lien, you have to adequately protect the lien that you're pushing down. Okay, you're not going to be able to show that. You understand that?
I understand. There's a reason the motion isn't filed yet.
Is BVD going to be agreeing to? Well, I guess they're here to be primed.
No, we're not.
No, they're
Okay.
not. We've already had discussions with them as well.
Okay. So, how much is the DIP loan for?
400,000.
So, when we go before the court on Thursday, and that DIP loan is not in hand, how are you going to proceed?
By Thursday, I honestly hope to have the final agreement drafted with the DIP lender so we can get that motion on file. The loan itself won't be in hand, but
Right, but it's
The motion in terms
a
should be-
condition precedent to, well, from my perspective, it's a condition precedent to this. You know, there's no judge I would know that would basically approve a budget that on its face is administratively insolvent by week 6.
understood.
So from a timing point, from a sequencing point of view, the approval of the DIP loan would have to precede this budget being approved. From my perspective, Judge Albert obviously will have his take on it. Okay, so you're going to be speaking to the DIP lender after you get out of here?
That's what I'm supposed to be doing today.
Okay.
I received the proposal on Friday afternoon.
Just out of curiosity, what kind of interest rate are we talking about?
On the DIP loan, I don't know off the top of my head.
Just north of 10%?
No, I believe it's somewhere right around there, actually.
Okay.
It wasn't a hard money loan.
Well, 10% is not exactly a gift. What is the duration of the loan? When it has to have to be repaid?
The duration, I believe, was within 6 months, but again, I'd have to look at the terms. I was so busy focusing on the new budget.
How are you going to pay back $400,000 in 6 months?
There's a, okay, so the agreement actually, it carries forward with potential asset restructuring and buyout.
Is
by
this
the
a loan?
finance.
Is this a loan to own?
Yes.
Okay, would have been helpful if you said that. up
Well,
front.
because it's not exactly, that's what I need to discuss with him, which is why I'm not willing to, state who it is and what
I don't
the
want to know who it is,
terms are,
because
so-
I like I said, whoever it
it's
is.
not, I don't know the person,
Yeah.
I've been
Yeah.
instructed not to say anything until we have it finalized.
Okay, all right. All right, I also noticed that within the part I'm looking at, I understand below you have it, I didn't see any line items for professionals or the proposed examiner or any type of thing of that. Am I missing something? Could you help
No,
me?
you're not missing anything.
Okay. So, I mean, you've got proposed financial advisor, you've got your firm, you've got,
That's all baked into the cash flows that I discussed with Brian, so under legal,
yeah, but it's not, I'm looking at the ending cash balance part of
Right.
it. That's a below the line, sort of just giving us a running amount. That's different. It's not baked into the top part of this budget, unless you can show me the line item.
This whole case is contingent on that DIP loan buyout, otherwise,
Okay, Okay.
You know, we're not gonna really move past week 8 probably.
Well,
So-
yeah, I'm
I'm not even sure we'll make it there, but I'm
Yeah,
just letting you
yeah.
know, like as a structure.
okay. All right, so now we've done, I'm not gonna even spend more time in the budget, because without the DIP loan, it doesn't make sense on its face the way it is, but certainly without the DIP loan, it makes no sense.
Understand.
So let's shift gears here, and let's start driving through these schedules. So we're going to do this the following way. We have docket item 1, docket item number 11, docket item 31. I'll just guide you guys through this, because what happens is the amendments supersede a lot of the schedules, so we're going to be shifting back and forth, back and forth. There's no other way for me to do it.
Michael, is there any way we could take a break so I can use the restroom?
Oh, of course.
And then is the third floor open to buy water?
I don't know, because I haven't been to the third floor in about 7
You
years.
can go in there, they have vending
Okay.
machines that have water.
Thank you.
Okay, why don't we take a 20-minute break? Actually, you know what? I don't want to do that. Let's take a 10-minute break,
Perfect.
and then we'll come back, because I don't want to be here all afternoon, okay?
Thank you.
Okay, we are back on the record, and this is 341 of Ultimate Brands, Inc. Mr. Griffiths, you realize that you are still in row?
I do.
Okay. We're now going to go over the schedules and statement of financial affairs. We're going to shift to docket item number 11, because those are the superseding amendments to A and B. And if you have that for Mr. Griffiths, if you can put that in front of him, Ms. Villalobos.
Yes.
Okay, so I just want to go over this briefly at page 7 of 23. Do you see that?
Which specific schedule are you looking at?
I'm looking at docket item number 11, and it's at the very top where the accounts receivable are listed.
Okay.
The $1.2 million and then the $400,000 write down.
Got it.
So I can show that.
I have it here.
Okay, so my question there is the $1.2 million, that represents all the royalties that were transferred, or I should say assigned on June 27th from UFI, correct? Let me put it another way. Did the debtor prior to June 27th have any accounts receivables?
Yes, substantial.
Really? Okay, so how much of the $1.2 million is UBIs, and how much? I know it's now all UBIs because of the assignment, but how much of it prior to June 27th was UBIs, and how much of it was UFIs?
There are no accounts receivable on Ultimate Brands. On Ultimate Franchises, they're substantial.
Okay, that's what I was trying to say. Are all does the $1.2 million reflect the royalty assignment of the royalties from UFI essentially?
It would represent the assignment of the royalties.
Okay,
That is correct.
Okay, that's all I was trying to confirm.
I'm sorry, I'm
no,
new to this.
No, okay. And the $400,000 write-down, that's uncollectible because of debranders and other franchisees.
You have multiple baskets in terms of the receivable. You have those which are collectible. You have those franchisees that may do their own chapter filings. So we did an estimate in terms of what the total is and what we think we can pursue and collect.
Do you have any franchisees who you have side agreements where you tell them they don't have to pay?
No, we don't do franchise abatement.
You're under penalty of perjury now, sir.
Well, we did talk to John Michael. I think there may be an issue with John Michael.
Who's John Michael?
He's one of the franchisees, and I've got to go back and look at some past agreements with him. He did a convertible note that I think was secured by franchise fees. Brian is working on that. We do have franchisees, and we accrue and show all their franchise fees are owed. We don't show any franchisees fees that are being forgiven at this point.
Okay, so just so I understand the math here, I'm not sure how you arrived at the $1.2 million number. If the franchisees are to remit the royalties every month and the cash collateral budget shows it's $75,000 a month, if they're paying timely, at most the receivable, meaning monies that are owed, should not be more than $75,000 because maybe they haven't paid it for the last month.
No, that's not the arithmetic we're working with.
Is this an annualized number?
No, we have receivables. We have franchisees that are paying every month.
Right, and
That's in the cash collateral. That's the 75,000.
Okay.
Okay. You have franchisees that are behind in their payments.
Right.
That want to. They don't want to be in default. They want to be current, and so they're simply behind in their payments. So that's a basket. You have franchisees in default of their agreements that shut down, and we show that we take their latest month of revenue and we show that as an ongoing obligation, but we expect that a number of those people, because they simply shut down, will not be able to pay. We may have some recourse. And then we have franchisees that debranded, that are in default of their agreements, and they debranded primarily to not pay royalties, so we take their latest royalty payment and the period of time that they didn't pay royalties, and we have recourse as an asset of the estate to go after and collect those royalties. And a significant portion of those people should be held accountable and should be collectible to the benefit of the estate.
And you understand that collection can be costly and that oftentimes pursuing delinquent accounts is fruitless. Just from a cost-benefit analysis, we're not talking about.
Well, we've talked to various resources about how to be as efficient as possible.
Yeah. All right. Moving down to question 15 here, or B15. You value Ultimate Franchises at $1.5 million. I don't see how you come into that number when all the assets of Ultimate Franchises was transferred the day before the case was filed. So how did you come up with that figure? I mean, it's really worth zero, right?
Yes, and with on a consolidated basis, Ultimate Franchises.
This is not okay. So just so
yes,
Ultimate Franchise Inc. is not in bankruptcy. These schedules do not reflect, other than the fact that the debtor owns 100%. Okay, the question here simply is, what is the value of UFI?
With the assignment, the value would be zero.
Okay, so that needs to be changed. So B15 UFI value equals 0. Okay. All right. Inventory and supplies, $400,000. I saw that you have a couple of warehouses that your wife, I think, is in charge of. Where's most of that product kept, in the warehouses, or
we have product
storage?
We have product in storage in Florida.
Yeah.
We have equipment and chairs, and I think there's a couple of locations that we have the equipment and the chairs. So they're in various warehouses.
Okay. So inventory and supplies, we're talking separate and apart than what's at the actual salons, correct?
Yeah. Yes.
Okay. All right. And is that for just the company-owned stores, or is that for the franchisees, or who's that for?
No, the equipment and supplies are...
No, the inventory and supplies, yeah.
Oh, the inventory, Ultimate Brands owns that inventory.
But do you sell it to the franchisees? Or?
Yes, we sell it to the franchisees.
At cost, or?
No, we have a markup on it.
And this is just the kind of stuff you would see, like, shampoo, conditioner?
Yes, yes, grooming products, shave products, the wet line.
Do you net that from the royalties? I mean, I'm sorry,
No, it's a separate charge, independent of the royalties.
Independent, okay. And as part of the franchise agreements, they can only buy the product from you?
They can only buy products that we authorize. There's other brands that they purchase.
But are they required to essentially carry and sell this product?
Yes.
Okay. So you have a captive buyer.
Yes, it's a very advantageous and part of our future. It's important.
Okay. Then we get to question B41, and that's sort of the FF&E, and that's just as to the company-owned stores, correct?
I believe so.
And you have that at $250,000?
Yes.
And you think that's truly the replacement value of that stuff?
That was our estimate at the time.
No, I understand. It
Yes.
seems high. I mean, most of the time, equipment goes for very 20 cents on the dollar type of number. So I mean, this would have to have had a face value at purchase of 5 times that amount.
The estimates at the time,
Yeah.
and we're in the process of updating, everything. So we'll re-review those numbers. Mike.
Yeah. Okay, then we get to the question 60, which deals with patents, copyrights, and I was going to ask you about the brand name, but we've already discussed it.
Mm-hmm.
So, Ms. Villalobos, does it have to be amended, or does it already say what you think it's supposed to say, which is, I mean, it's pretty vague. It says trade secrets, trademarks, digital real assets, IP address. You want to just leave it at that?
If I have a choice, yes.
Okay. I mean, we have the testimony. The way it's drafted, it doesn't exclude.
I wouldn't even know how to value it at this point.
No, I'm not talking about valuation, but just the fact that the brand name is an asset of the estate. So there's nothing in here that says it's not. Okay, so
Exactly.
why don't we just leave it as is? B62, which is the,
Licenses?
yeah. Why did you originally schedule the royalties there and then you took it off? And that's because the debtor was not in contractual privity and you merely have it through the assignment?
Yes.
Okay. Okay, so moving on to Schedule D. So in order to do Schedule D, we now have to shift to docket item 31 because it was a superseding amendment that was done. So we talked about this earlier. So you've got two secured creditors, BVB and Maxim, and you indicated that you thought you needed to amend Schedule D to better describe Maxim's
Maxim,
collateral.
yes.
Okay. Then we're on to E and F, which is the priority and unsecured debt, and that also we're going to have to look at docket item 31 because from what I could tell, there was one amendment, and that was simply eliminating the duplicate claim of Scott Griifiths twice. I didn't understand. Other than that, was there any change between? That's what I caught as far as the amendments. If you look at the original, there's 18 creditors, and Scott Griifiths twice at $600,000, and then it goes down to 17 creditors. But anyways, I'm going to ask you about docket item 31. So let's get started. Okay, so we have the franchise tax forward at $50,000. We haven't seen a proof of claim, so we'll just leave that at that. The IRS you listed as, you don't dispute that you owe at least $150,000. Is that correct? Okay, and obviously there's a proof of claim file, and that'll be resolved one way or the other. With respect to the general unsecured body, I'd like to ask you some questions about these creditors. Ms. Villalobos, I would just make a point that on almost all of these creditors, there is no date for when the debt was incurred. So, for example, if you start at the top with BVD, where it says date that was incurred, and this is pretty much throughout, with well, I think one exception, there's just a blank there.
Understand.
In addition, on many of these where it says basis for claim, sometimes you have a lawsuit, but other times it'll just be blank. So we do need to amend Schedule E and, well, not E, because I think those were done correctly, but F, I should say.
To add the dates.
We need the dates that incurred, and in some cases, the basis.
Okay.
Okay, so BBD, we've had enough documentation on file with the court to understand what that's about.
I believe that was another change, because the original schedule had them in Schedule F, so we moved them over to Schedule
Oh, yeah,
E.
you are correct. You're correct. So BBD is no longer on Schedule F, and so we're starting with Applegate then, okay. So Applegate, basis, what's the basis for that claim? What's the relationship?
Basis for the claim
In a nutshell, just not a
Yes.
big amount, so just keep it, if you don't mind,
Okay.
just keep it short.
there's a previous organization, former partner, we agreed to a settlement, and this is a former company, we acquired the trademark from that company, and we agreed as part of the settlement that other entity was responsible for the obligation, but if that other company failed to meet the obligation, then Ultimate Brands, should we give you a paying timeout?
No. What does Applegate do?
Applegate was a former partner, he doesn't do anything.
Okay, so this is a former partner of UBI?
No, of a separate corporation, Monoconcepts.
So why are they listed as a creditor of UBI?
Because as part of the settlement, because we originally acquired the trademark from that entity,
Trademark of what?
the 1885 Men's Salon trademark was originally acquired from our predecessor company called Monoconcepts.
Okay,
And as part of the settlement, we agreed with his legal counsel that there would be, that Ultimate Brands would be a backup for any final amounts of money that are due, so there's a relatively
okay,
small
so
amount
this
of money
resulted
due.
from UBI guaranteeing payment on this transaction?
On behalf of the settlement.
Of a prior entity, okay. Avitus, you already said this is a third-party payment company?
Supplier,
Okay, so that would be a service, we'll call that.
yes.
And at the time you severed relationships, you don't dispute it, you owed them $70,000.
No, we do dispute that, absolutely.
Okay, well then you need to amend that too, because, okay. BLD Capital, I think they're here. This is meant without any negative connotation. They're a hard money lender?
No, they were an investor that purchased a convertible note,
Okay.
and for various reasons we don't have to get into, they chose not to convert.
Okay.
And now the $500,000 that did not convert, they want their principal back, in a nutshell.
Okay, so they invested and you'll put the date when that investment was made?
It was made in April of 2018.
Okay. Centerpoint Financial, they're right here in Newport or Irvine. So that was a loan?
No, Centerpoint is a landlord.
Oh, Centerpoint Group, I'm sorry. My apology. Okay, so this is a landlord? Was this one of the company stores on the eviction? Or was
No,
this...
that's where we had our corporate location.
Okay.
And we dispute the amount.
Understood. Curtis, and that's on here, right? So, okay, Curtis Loeb?
That's a franchisee that did not develop, and he basically wants his
Okay.
money back.
I see Dillon Girardi, which is the same entity that represented Applegate, so why are they listed separately for $100,000?
They actually became, for a period of time, our general counsel,
Okay.
and so there's a residual balance.
So they're lawyers.
They're lawyers, and
Okay.
we dispute the amount.
Which
Okay.
does not have to.
I understand. DJ Bunka, that's what was the underlying basis of the lawsuit?
Bunce was a former franchisee. We agreed to take back his store.
Okay, that's
Yeah.
okay. Move on. Teskey, what was the dispute there? Franchisee.
That's where we came in under a management agreement.
But they were franchisee.
They technically still are a franchisee.
Okay, that's all I really need to know at this point. Okay, Griffiths is you. It says 600,000, and it says you loaned over a.
That's the Griffiths organization, right?
Yeah. And so my question there is, when was the money loaned? You have a 10-year time frame in there.
Yeah,
Which-
accounting is doing a detailed update for loans that I made to the Griffiths organization, Griffiths. As part of the new amended filings, those details will be provided.
It wasn't a lump sum.
Okay, so was there a written agreement between the Griffiths organization and the debtor documenting?
Yes,
the
we
loans?
have at the board level minutes that loans would be provided on an ongoing basis, and there's an interest rate that would be.
Okay, board minutes is one thing, but there's an actual documentation called the note, promissory note, between UBI and the Griffiths organization.
We have notes, and I have to go into the files and get those notes.
Okay, well, I'm not asking for them, I'm just asking if they exist.
They exist.
Okay. Hakan Yasser Kilik, what is that?
That's a former franchisee
Okay.
that made the decision to exit.
Happy Rock is a hard money lender.
Yeah.
Well, and please put the date, but what's your recollection as to when the loans were taken out?
The last advance was made February of 2018.
When did it start?
February 2018.
Okay. So what prompted you to go to a hard money lender to take out a $60,000 loan?
Well, that's the residual balance.
What was the initial balance?
The initial balance, I think, was $220,000.
How much do they actually give you? Oftentimes the balance is different than the amount.
Yes. Well, it paid down a previous loan, and then I think we had a new note. So I think we netted out of the new note $140,000.
So this was February of 2018?
Yes.
Why did you need money in February of 2018?
Because we have ongoing cash flow needs, and we had no access to any other capital, and I was tapped out.
Okay. What about, and did you execute an ACH agreement with Happy Rock so they can hit your account?
We did.
Did you close that account so they can?
Yes.
Okay. What happened when you closed the account? They sued you?
Well, I have a decent rapport with the owner, and I've been keeping him up to date. So, but he is a creditor with the UCC filing.
Okay. What about Shaw? What's the lawsuit about?
That's a franchisee that chose to shut down his store.
Okay. And then the Patterson, Wheatstrong, etc. Mr. Mitnick's here, so I'm not going to go into detail, but just tell me basically what was the underlying nature of the lawsuit, whether it's a franchisee dispute, was it some other dispute?
He's a debrander, and so we had a dispute with them, and he has a
Okay.
dispute with us.
I understand. And was it, how many stores was it?
One.
Okay. Okay. And then, so the Orchard Lake Forest, it says that's an eviction matter. That was a company-owned store, or?
Lake Forest is company owned. It was resolved.
And we got looks like another Regency Centers. Is that an eviction matter as well?
That was the landlord for Teskey.
Okay, that's just. So, how did it come to be that you were on the hook for a franchisee store? Is that the way it is on all the franchisees?
No, that's very rare. What we, Teskey was, I mean, it's complicated, but basically we took over, agreed to manage the store, and we had a side agreement with the landlord that Teskey had like $60,000 back to rent. We said that on an ongoing basis we would be a co-guarantor of the loan. It was a mistake, but then we went to the landlord. We weren't able to make it work,
Okay.
and so the landlord has us on the hook.
Okay,
as well.
so then we get to creditor 3.16, and it says Scott Griifiths, and in the amount of $600,000. Is that a duplicate of 3.09, which is the Griffiths organization?
No, they're two. Griffiths organization has made loans over the years, and Scott Griffiths personally has made loans.
So it's
over
just
the years.
coincidental that they both lent exactly $600,000?
Well, those are estimates. We're getting the exact. We're doing a forensic accounting to get the exact numbers.
So were there notes executed between UBI and Scott Griffiths, yourself?
There are notes executed between UBI and Scott Griffiths and UBI and the Griffiths organization. But the loans have been made consistently over a period of time. When the company has needed money, I was the lender of last resort. So I haven't gotten paid back for any of the loans I've made over the last 8 years.
How are the loans, how is the money transmitted? Electronically or
It could be checks, it could be electronically.
but there's a paper trail, in other words, it was never
Yes,
cashed.
the Cynthia, who has a background in forensic accounting, is doing a deep dive detail on.
When was the last time you personally lent money to the debtor?
3 or 4 months ago.
How much was that?
I don't know, different amounts, maybe 40, 50,000.
Okay, and how was that documented?
Documented is probably email communication, that there was an obligation. It was documented in the notes to Cynthia and to Aaron that the loan was being made. There's a schedule.
How were the funds transmitted from your personal account to the corporate account?
Sometimes it was checks, sometimes it would just be a interbank transfer. I will say, when I was making these loans and doing this, we were optimistic that investors were coming in and that the kind of scrutiny that we're now facing was never going to happen.
Yeah, I'm not really concerned about the optimism or lack thereof. I'm just concerned about the fact that you have $1.2 million listed owing to either you or your entity here, and unless you're going to agree to voluntarily subordinate, you're going to have to document the heck out of it.
Cynthia's documenting the heck out of it.
Well, and more importantly, Cynthia's primary job is to this company,
Mm-hmm.
and I would hope that she's working on cleaning up all the list of things we need to do here before she does your personal business.
Cynthia and Brian, I think, are doing an absolutely professional job, and my input to everybody is make sure you do an absolutely professional job, and they have my support to do everything that you're asking for.
Well,
Past and
it's you got franchisees here, you've got a whole host of people here, you've secured creditors. These are the people that want answers.
I am a large creditor, and I'm absolutely dedicated to doing the best I can for all the creditors.
Right, but you're wearing a lot of different hats. You're a large creditor, but you're also a personal guarantor on the largest secured debt. You're also are responsible for the trust fund taxes, which could be anywhere from the $200,000 you've scheduled to $600 or God knows how much, because we haven't seen the proof of claim of. So, it's you got different hats here, and they cut both ways.
Understood. But this is why I have Brian, and who's directing everything. He's been through this drill many times, and so working closely with Julie, working closely with accounting, I think he's doing a very professional job. And if it's not good enough, we'll do better.
Well, here's the problem, Brian. Brian was the one who advised you to make the transfer on June 27th. So I think he's, whether he'll be employed by the court's highly questionable. I think a lot of the parties here are going to have issues with that, but we'll see. So, last creditor here is Harder. What was the underlying nature of that? Was that franchisee?
Franchisee in default.
Okay. So now we move to Schedule G, and that was amended by docket item number 11, which supersedes docket item number 1. And all I want you to do is confirm for me that these 5 contracts listed here are for the company-owned stores. There's Costa Mesa, Pasadena, Temecula, Scottsdale, and Lake Forest.
That is correct.
Okay, so these are, and the corporate headquarters, that eviction took place in the fall or something.
That is correct.
Okay, so these are the company stores. And we've already discussed, just so it's clear on the record, that the debtor is post-petition delinquent in the amount of $15,000 on the Lake Forest and Costa Mesa stores, correct?
That's an estimate.
An estimate. In addition to the post-petition delinquency on the payroll taxes of between $10,000 and $15,000, correct?
That is correct.
Okay. So now we're moving on from Schedule G to Schedule H, and that's the co-debtor. That's where you say where you're liable for other debts, and that was amended, superseding amendment, which is docket item number 11. And on Schedule H there, you list yourself as a co-debtor, meaning you're also responsible for the loan to Happy Rock. But I don't see you listing BVD, which you're also on the hook for. In fact, you were sued by BVD.
Yes. At the time, there was a dispute as to the legitimacy of Mr. Carpenter setting up a separate purchasing the loan, and so it.
Okay. Ms. Villalobos, I'll leave it up to you. Do you believe that even though he's on the note named as a guarantor, that he should not be on Schedule H? I understand you disputed, but because BVD, I don't know why BVD would be precluded from buying a note. From
My
bank.
understanding is that Scott's opinion is that he's a personal guarantor to Ojai Bank, but he didn't want to list himself as a personal guarantor to David Carpenter 660 BVD.
What's the bank's position on that?
The bank's position?
Yeah.
I mean, he personally guaranteed this loan. I'm not sure I understand his response or her response.
That's all I was asking. Okay. All right. So I'm gonna, I can't force you to amend it. It's to me.
I think we should amend it.
It doesn't mean you can't dispute.
Yeah.
I mean, they've sued you. It doesn't. And by the way, are you proceeding in state court with that action against them?
Yes. So there's 2 separate actions, one against franchises and the corporate entities. Both are proceeding, except state against the debtor as to the corporate action.
Okay. I mean, where are we at? Where is that in the state court as far as, are you at the pleading stage? Or are you at the...
Yeah, well, writs of attachment have been issued against Mr. Griffiths and Ultimate Franchises post-petition, and so we're beyond the pleading stage at this point.
Okay. Okay. So then we've got the next document is going to be a statement of financial affairs. That was amended by docket item number 11, so we're going to flip to that. Let's go to page 19 of 23, question number 20. You list there some off-premises storage. It lists 1, 2, 3 storage facilities here in Tustin, and it appears that your wife is the person who has access to it, is that correct?
That is correct.
And this holds the $400,000 of inventory, is that correct?
Well, there's the manufacturer of our products
Yeah.
put the products in a warehouse in Florida.
Okay, so essentially they drop ship it, meaning you get an order from a franchisee.
No, they don't do a drop ship. What we do is when we need product, we'll bring it out. Historically, what we've done is we brought it into the corporate office and then we would disseminate it out of the corporate office. So we're now looking at bringing all that product, putting it into California, and we have, because of what we're going through now, we haven't reconciled what we're going to do.
So then everything that's in these 3 storage facilities, that would be under the header of FF&E.
That's correct.
Which is the $250,000 number we discussed on, again, we're talking about non-product, correct?
That is correct.
Okay. Do you want to add something to that? Or?
No.
Okay. On question 25.1, where it says Ultimate Franchise Inc., and you describe the nature of business as a franchise payment pass-through, is that historically how essentially the funds were treated, as simply moving from UFI to UBI?
Yes, there's been intercompany, and Cynthia has done the forensic accounting on all the intercompany, but it's moved back and forth between the two companies.
All right. And who is Erin Vanderveen? She's listed as one of the people who's got the books.
Yeah,
back.
she's a bookkeeper.
Is she a W-2?
No, she's a 1099. She has her own company.
Okay. And then Cynthia Diaz is the person you've been referring to quite a bit?
Yeah, she's a professional CPA, and she's on retainer.
Okay, and then we look at the question 28, which is again, essentially breaks out the list of equity holders. And you've got Scott Griffiths at 65%. Do you personally own 65%?
Well, that would be me and my affiliate, like Griffiths Organization and
Okay.
Scott Griifiths.
So let's amend SOFA number 28 to reflect who really owns. That's somewhat misleading. It makes it appear that he's
Understood.
directly.
I'll amend it to reflect what we amend number 3 for the list of equity holders.
Okay, all right. So as we sit here today, is it just you and your wife are the officers of the corporation?
That is correct.
Okay, so we've gone through the budget, the schedules, IRS proof of claim, your declaration. I've got a few more questions I'm going to open up to. In reading your status report, you indicate that your exit strategy is to sell the debtor as a going concern. Is that correct?
We believe that's a very viable option, and we have investors that are highly interested.
Okay. Are most of those investors existing franchisees?
No, not necessarily.
So you have people other than existing franchisees?
Oh, absolutely.
Okay. And prior to the bankruptcy filing on June 28th, were you actively marketing the debtor as a going concern?
Yes.
Okay. And how long were you doing that for?
We've been doing it on an ongoing basis, but over the last year, we were actively seeking to sell up to a majority or all of the company.
Okay. So as we sit here today, you're saying that there's interested parties, and I think Ms. Villalobos indicated on the record when we were talking about the cash collateral budget that absent that $400,000 DIP loan, that the cash collateral budget wouldn't work, but that DIP loan is really a loan to own by one of the franchisees, correct?
Well, we have serious interest there, but separate from that, we have very sophisticated investors that are very interested once we clean everything up.
But just to step back for a second, we've already established that the cash collateral budget will not work unless there's a DIP financing.
That's great.
Okay, and then that led to the whole discussion about a $400,000 DIP loan, and then I said, why would anyone do this unless they were somehow interested? And then Ms. Villalobos, it finally came out that it's an interested buyer on a loan-to-own basis. So if that person does the DIP loan, they're the buyer.
Okay.
How is it not? How are they not the buyer?
Well,
you have a 6-month term. There's no way this debtor can pay back $400,000 in 6 months.
Right.
Okay.
Okay. I'm going to have to say, Michael,
Yeah.
I don't know because I've been relying on the expertise of others to coordinate all this. So we would have to, I can't personally answer with expertise.
I can tell you that's the way that we plan the case to go.
Okay. So you plan to obviously the hearing. Well, either you get all the paperwork done on the DIP loan before Thursday, and the court can absorb it, which I don't think is humanly possible, or the cash collateral budget's kicked out. You get the DIP loan on an emergency basis before the court, and it's either going to have terms that are acceptable or unacceptable to the court, because it's necessarily going to put a hammer lock on the future of the case.
Yes, the crux of the case.
I mean, it is. Let's just cut through it. It is essentially the sale of the debtor. It's because it's going to necessarily have terms in there that's going to dictate when they have to be repaid.
Mm-hmm.
Yes.
Mm-hmm.
Okay, so getting back to the exit strategy. The exit strategy is the DIP financing.
As I understand it, yes.
Because that will lead to this DIP lender credit bidding the $400,000,
Right.
and maybe putting a little bit more money in to cover the first that's held by BVD.
Correct.
Okay, so that's the framework that we've kind of fleshed out here this morning.
I believe so.
Okay. So when we get to the hearing on Thursday, you're going to present this to the court in the fashion we've just discussed?
That's the plan.
Okay. Were you intending on informing the court that we're actually absent getting the DIP financing done, that it probably shouldn't, that this is coming down?
Well, what we're asking, my intention on Thursday was to ask the court I'm looking at him because we have a very brief cash collateral use in place, and as discussed telephonically, it's going to go like 2 weeks at a time per stipulation with 660 BVD. Obviously, that's pending court approval. So the intention was within the next 2 weeks, everything needs to be done. So on Thursday, I was hoping to have the DIP financing motion drafted and in place for the court to have it on file, and to do an emergency hearing on that and push out the cash collateral hearing for that same date.
Okay, so
That was going to be the request.
what I'm hearing you say is you're going to ask the court to please give you a 2-week use of cash collateral, even though the case would be administratively insolvent without the DIP loan, in the hopes that the DIP loan will be approved by the court.
Yes.
Okay. Is there anything you want to add to the sale as a going concern vis-a-vis the DIP loan?
No.
Okay. Okay, so we're going to continue this 341 meeting to, I'm going to open up to creditors to August 12th at 10 o'clock. And I'm going to go through the list of amendments that we discussed, but obviously first and foremost I need the 2015.3 form filed with the court.
Which I have.
Okay, then we also talked about the further amendments to Schedule D. the amendment to the list of equity holders. We also talked about the fact that the cash collateral budget itself, and you're going to have to explain this to the court on Thursday, or I will, which shows a budget based upon 9 stores is really
Should be
only
7.
7 stores. So even, I mean, are you going to be filing an amended budget with the court?
I doubt that I'll have that by Thursday.
So,
I'll be focusing on the DIP financing motion.
okay, but I mean, like I said, obviously I will inform the court as to what happened here today with respect to the loss of 2 stores and that the revenue is not what it projected on that. Okay, so even though we had this on the list, you're not going to revise it at least for this Thursday. We talked about amending B15 so that the valuation of UFI is to 0 as long as that assignment's intact. We talked about amending Schedule F because almost all of the creditors have no dates as to when the debt was incurred, nor does it actually state the underlying basis for the debt. Although we discussed it on the record, I think creditors who want to look at it might want to see the years that the debt was actually incurred and what the underlying basis. So like when he just said, oh, it was a franchisee's dispute, that would suffice. We don't need a paragraph, just,
Okay.
but blank is not helpful.
I took notes.
Schedule H would need to be amended to list BVD as a debt that he's personally. And SOFA number 28, I think same issue with the equity holders is somewhat confusing. Those are the amendments I had. At this time, so the continuation date is going to be August 12th at 10 o'clock. It's not going to go as long as today, I can guarantee you that. And maybe it'll be really short.
Okay.
Okay, at this time, let's get a show of hands of timing so we can just do this in an orderly fashion. The bank, why don't you come up first, since you're going to be co-sponsoring the cash collateral budget, which we now realize, just for my edification, were you aware of these issues with the salons and the necessity of the DIP financing as a condition precedent, or is that news to you as well?
That the understanding that there would be DIP financing coming in has been described to us in our negotiations regarding the cash collateral STIP. We have received information recently about the 2 store closures from Mr. Guadano. We haven't seen a revised budget in that regard. I think 660 BVD's position really as far as cash collateral use is that it's more of a retroactive consent. The case was filed at the end of June, and so we had all of July that there was unauthorized use.
Sure.
So I think that's why the permitted use was only until this Friday. And we recognize the deficiencies of the budget. We understand that it's contingent on some sort of DIP financing that we've been waiting for information for quite some time, and we haven't received any real documentation.
Don't mean to interrupt, if you can just state your name for the record and you represent.
Keith Banner of Greenberg Lusker, representing 660 BVD LLC, secured creditor.
And just, if you can give up your voice a bit since you're a little bit further away.
Okay. Good afternoon, Mr. Griffiths. As I mentioned, I represent 660 BVD LLC in this bankruptcy case. I know there's a lot of patient creditors waiting to ask questions. I only have a few questions for you, so I would like to inquire a little bit more into the transfer of the royalty, the assignment of the royalties from Ultimate Franchises, Inc. to the debtor, Ultimate Brands. And I understand that, okay, so as far as the arrangement with franchisees, there's an agreement, as I understand from your testimony, between, in each case, between franchises, Ultimate Franchises and each franchisee, that's correct? Mm-hmm. And there's an agreement that payments will be automatically transferred via ACH or another method from the franchisees to Ultimate Franchises, correct?
Mm-hmm. Or anybody that we assign to receive those monies.
Okay, are those monies, whose account are those?
You need to say yes or no.
Yes.
Whose account currently are those monies going to? And they're still going by automatic ACH, correct?
Yes, it's
Okay.
going in a Ultimate Franchise account.
Okay, so notwithstanding the assignment, monies are still going into accounts of Ultimate Franchises.
That's a yes or no question, correct?
Yes.
Because there's more
It's
complexity.
a yes or no question. Whose name is on the account that the money goes in?
It
That's all I want.
is currently, well, the last payment, which was for July for June has already been received.
Okay, and it was received into the ultimate franchise's account.
Into the previous account.
And then where does that money go after it goes in ultimate?
Then
franchise's
it's
account?
transferred to operate. There's been intermingling from day one between the ultimate franchise accounts and the other businesses.
Okay, so the money is moved generally to the debtor's account or
It's moved to cover payroll and various
Are
rents.
there other
and
entities where that money would go to, or is it just the debtor?
It could go to two Ultimate Brands. Historically, it could go to Ultimate Brands, Ultimate Franchises.
I don't want to. What does
There's
two
three
ultimate
main
brands
things.
do?
Two Ultimate Brands historically was education and training, product development, certain areas of promotion. They have not existed distinctly and separately since they're wholly owned subsidiaries. And we've been somewhat entrepreneurial in how funds have moved around, given that everything's been very fluid.
But what do they currently do? Why would there need to be money to go into two?
Currently, two Ultimate Brands is dormant, so funds are not moving. I'm talking about historically.
Okay.
So the ACH forms have been updated, so the next royalty is scheduled to go into the DIP account for the July royalties, is scheduled to go into the DIP account at Wells Fargo that was set up and required by the trustee.
And that's for every franchisee? All
That would be
royalties?
for every franchisee that is paying.
Okay.
So the objective is for all funds to flow into the DIP account.
But for July, all the payments via ACH went into
No, for June.
franchise. Or for June.
June.
They all, pardon. So for June, they all went into franchise
They went into a
bank
franchise account.
And then they went into the debtor's.
And then they are disseminated, accordingly, without silo discipline, whatever our bills are
Okay.
that have to be paid. Essentially, the cash that's coming in has been paying to operate the business, and there has not been a lot of excess funds to work with.
Okay, in your, going back to your schedules, we spoke about it briefly. You had listed the various lawsuits. I'm looking at docket 11, the statement of financial affairs, page 16 of 23. That's where you listed the various lawsuits that you were involved in, or the debtor was involved in at the time of the bankruptcy filing. At number 7.10 and 7.11, you listed the two state court actions pending in the Superior Court of Santa Barbara, initiated by 660 BVD, correct?
I believe so.
All right, and in one case, it's 660 BVD LLC versus Ultimate Franchises, Ultimate Brands Inc., and two Ultimate Brands, correct? And then the second action is 660 BVD versus you personally. There's two separate actions.
Yes,
Okay, you had noted.
Let me, can I expand?
Well, let me, I want to understand, you had noted on the Statement of Financial Affairs that both of these actions were concluded at the time of the bankruptcy case. Was that just a typo on the bankruptcy schedules?
They're not concluded, are they?
Correct,
Yeah.
that was exactly my question.
Yeah,
There's
no.
two actions currently pending against, one
They're-
against you and one against the entities.
We
included.
understand there are actions pending.
Okay, I just wanted to make sure that was clear based on this notation on the schedules. So, as to the pending actions, as I understand, immediately before the bankruptcy filing, there was a pending motion for a writ of attachment in both actions against you personally and against all the entities. Is that correct?
I believe so. I would have to go back to general counsel on details.
Okay, if it may refresh your memory, I think the motion was filed initially at the end of May 23rd, 2019. And you also had filed an opposition with your own supporting declaration on June 5th, 2019, beginning of June.
With general counsel,
Yeah, so you submitted a declaration in opposition to that motion.
we did.
Okay. And when the bankruptcy was filed, those motions were pending, correct?
I don't know the exact timing.
Okay. Are you, and post-petition, after the bankruptcy was filed on July 19th, 2019, writs of attachment were issued against you personally, Ultimate Franchises, and I believe 2 Ultimate Brands, correct?
My understanding through general counsel is that there were hearings in Santa Barbara. There was a request for writs of attachment. And we had a dispute with, as you know, we had a dispute. I don't have a dispute with Dave. As you know, we have a long relationship together. It's unfortunate that the situation exists.
Are you aware that writs of attachment were issued against Ultimate Franchises and you personally?
I'm aware, no, not against me personally. I'm aware that there was a request for writs of attachment, but that the court had not, in Santa Barbara, had not approved the writs of attachment.
Well, I certainly hope your counsel would have informed you that a writ of attachment is a very serious remedy, and I would hope that your counsel would inform you that writs of attachment have in fact been issued, especially against Ultimate Franchises. And there are certain ramifications when there's a writ of attachment and writ of attachment against an entity and their bank accounts are used for other purposes.
The latest communication by my general counsel with me was that there was a request for writ of attachment, but because we had a dispute with the nature of the claim, which you're familiar with, that the judge had not approved the writs of attachment and that they were pending, and that the bankruptcy in part was to stay that action and that we would address it in the process of the bankruptcy.
I think that description would be accurate as of the bankruptcy, when the bankruptcy was commenced, what we call the petition date, but certainly after the bankruptcy was filed, writs of attachment were issued against these entities, except the debtor.
I'm not familiar with the details.
Moving on, just a couple other questions. You had mentioned on the record today that Happy Rock, when we were talking about the Happy Rock loan, the hard money loan, you had mentioned that they were a UCC filings creditor. Did they file a UCC statement against the debtor or against another entity?
They filed against the debtor as well as Ultimate Franchises and 2 legitimate brands.
Okay. That's an interesting point because I do not see them on Schedule D. Am I missing something?
Well, maybe they didn't do a
This is the
UCC
first I've
filing.
heard of
I'm
it.
assuming that they did the same way
Well,
the previous bank did and Maxim did. So maybe they didn't.
Well, let me ask you a question. Ms. Villalobos, have you had a chance to do a UCC one
I
search?
have, and I did not see that there.
Okay, well, then they haven't perfected their lien, at least not as to this debtor.
Yeah. So
I mean, the record is what it is.
Okay.
And it also, timing is also an issue. But have you run a UCC one search?
On the debtor, they were performed previously, not as of the petition date. So
Okay.
Happy Rock didn't come up. That's why I was inquiring.
Okay.
Has any other property, money, or other rights been transferred to the debtor besides we talked about the royalties for the franchisees, we talked about the
Brand name?
the brand name, the trademarks. Has anything else, any other entity or any other person been assigned to the debtor?
no, there's no other assets to play with.
So it was
I
just-
think the answer is no.
Franchise rights and trademarks were assigned
Yeah,
to the debtor.
the values are the trademark and the franchise rights.
All right, I'm sure we'll have plenty of more time to speak. Thank you for answering my questions. I appreciate it.
Okay. Is there anyone else who wishes to come up and question the witness?
You know what, I'm hoping they're not duplicates, so why don't you go ahead? Yeah, that way. can only ask one or two, and don't get mad at me for being here so late.
All right.
Okay. If you'd be so kind as just to state your name and who you represent.
Jeremy Rothstein. I represent the unofficial committee of franchisees
Okay, what firm are you with, sir?
with G&B Law.
Okay.
I'd like to return to the transfer of the trademarks. Do you recall when they were transferred out of the debtor?
Yeah, they're transferred at the time of the bankruptcy filing.
They were transferred out of the debtor at the time of the bankruptcy?
No, Ultimate Franchises folded and in the contracts, we have the right to transfer it anytime without notice.
He's
So-
talking about the trademarks.
Huh?
Trademarks.
Oh, you're talking about the Ultimate brand?
I can see where this is going. You guys are going this way. So
Yeah.
he's talking about.
You're talking about the
transfer of
1808 Fine Men's
royalties.
Salon.
Right.
1808 Fine Men's Salon is a trademark that historically was owned by Ultimate Brands and licensed to the franchisees. Okay? Ultimate, I'm sorry, you guys got to forgive me. 1808 Fine Men's Salon is an asset of Ultimate Brands.
So but at some point it was transferred out of Ultimate Brands, correct?
At some point, the franchise attorney was mistaken in the action. The asset exists or is an asset of Ultimate Brands.
There's a file in the U.S. Patent and Trademark Office that says that the Ultimate Brands assigned it to the S.L. Griffiths Trust.
I understand, but that was inadvertent. It's an asset that has to be reassigned or we have to negate that action. It is an asset of Ultimate Brands.
All right. At the time, did the secured lender, who I think at that time was Bank of the Sierra, consent or know about the transfer?
Well, given that it was inadvertent, to contact them and share that information with them was not something. I was surprised when I saw the transfer myself. So,
When you say inadvertent, what do you mean?
that the franchise attorney direction on another matter was confused about the transfer of the 1808 trademark, and so it has to be negated. It is an asset of Ultimate Brands.
So were you unaware that it had been transferred?
I was unaware that it had been transferred.
Well, let me ask this question. What was the purpose of forming the S&L Trust?
The S&L Trust was formed years ago for the benefit of our children, and we moved our house and other assets into the S&L Trust, so it had nothing to do with.
Okay. So it was a
With
basic
Ultimate
pour-over trust designed to leave
Yes.
assets. Okay, and as we sit there today, that S&L Trust still exists,
Yes, it exists.
and it has the assets for the purpose of what it was designed for?
Yes, that is correct.
Okay.
So for the purpose of this hearing, the asset of the trademark belongs to Ultimate Brands. And whatever going through documentation, it doesn't matter if mistakes were made or not, it is an asset of Ultimate Brands.
Understood. Has the trust received any other assets from the debtor?
No,
Any assets from the debtor subsidiaries?
no.
All right. In your initial schedule, you said that the debtor had $30,000 of cash. By your status report, that was down to $1,000. What
It
was the
was-
cash spent on?
That was amended because the confusion was cash versus what was in the account. And so the clarification was that it was actual cash, and we didn't have actual cash, so it was amended accordingly.
Moving to a secured debt, the maximum commercial capital loan, are you a guarantor of that loan?
I am a personal guarantor of that loan.
Is
Okay.
that-
So can we add that to Schedule H, because I didn't
Yeah.
see. I apologize. Go ahead, I'm sorry.
Is that guarantee secured by any of your assets? Is there a lien on any of your assets?
You mean my personal assets?
Personal assets?
Yes,
What assets?
my home.
And the 660 BBU loan, is that also secured by personal assets?
Well, the way the loan was set up, David and I were both personal guarantors. So I'm sure his counsel is of the position that 50% of that, what Dave and I guarantored, half is his and half is mine. So the residual obligation on that note, if it were not to be paid back through other means, is likely to fall onto my shoulders.
Right. And is there a lien on your?
No.
Okay.
No, it's just a personal guarantee.
So
As
that-
far as I know, is there a lien on, I don't think there's a lien on the property.
Attachment, apparently.
Yeah, I believe there's a lien that's been placed on your property pursuant to the writ of attachment.
Okay, because when we did a title search, we didn't see it.
You may want to run another title search.
Okay. All right, thank you.
That's my understanding.
Okay.
I'm
We'll
not
talk
state
to
court
John
counsel.
Dennis when we get out.
Yeah, we'll get clarification on that.
Thank you. Does the debtor have any other secured debt that isn't listed on the schedules?
Secure debt, well, we talked about Maxim.
Right, Maxim and 660 BBD are listed on the schedules. Is there
Right.
any other secured debt?
Well, there was a question on the Happy Rock, but, so,
That's answered. You answered that.
and I would say right now, I don't believe there is.
All right. Did you know that that Centerpoint Group LLC has a judgment lien against you?
Personally,
Against the debtor?
yes, we are aware of that. We're in dispute with the amount, but yes, there is there was a judgment. As a former landlord, we owe them money, if there's money to pay.
Well, what he's saying is a judgment lien, which means that they recorded an abstract against the company.
Yes, we're aware that there was a lien against the debtor.
Could you amend the
Yeah, I
schedules?
was not aware of that.
What's the name of that entity again? Centerpoint Group?
Centerpoint with an E at the end of Centerpoint Group LLC.
Okay. So they were initially one of the 20 largest, and now they should be moved over to Schedule D.
Got it.
There's also a UCC financing statement filed by Corporation Services Company as representative on August 7th, 2018. Are you familiar with that?
I don't know what that is.
Did you take out a loan around the time of August 7th, 2018?
Could you just say the name was again? Sorry, I missed it.
Corporation Services Company as representative. So they were representative for somebody.
I
I'd say.
don't have the faintest idea who that is, and I don't recall taking a loan out at that time.
All right. Another debtor on that statement, which you said you're unaware of, is 1818 Fine Men's Salon. Is that a separate entity?
No. It's a DBA of the corporation, but it's not a business entity.
Okay. Another debtor is the Griffiths organization. Well, we went through that. There's also a debtor on that called GO, the letters G and O. Is that a separate entity?
That's Griffiths organization.
There was another UCC financing statement filed by the Corporation Services Company as representative on May 19th, 2016. Are you familiar with that?
What's the name of the
financing
entity?
statement? So it's Corporation Services Company as representative. They are a service provider. They would have been filing on behalf of someone else.
I haven't the faintest idea who it is.
Do you recall the debtor borrowing money around May 2016?
I don't recall anything specific.
All right. Another debtor on that statement is 188, written out. Is that a separate entity?
No, there is no separate 188 entity.
All right. There's another UCC financing statement filed by ASSN Company, also as representative for somebody, on December 31st, 2015. Are you familiar with that company?
No, these are all
Did you,
mysteries.
do you recall borrowing any money around December 31st, 2015?
We didn't need to borrow at that time. We were happy as clams at low tide.
All right. There are also some notices of tax lien that refer to converged salons.
That is completely, and our accountant is working on that, but Converge Salon, we never had any business ownership or interest in Converge Salon. It was a location where we purchased the location to set up an 18-8, but we never had a business relationship with Converge, and our accountant has been frustrated in trying to get that removed.
So it is a separate entity, but
We have
You are not
no,
affiliated with them?
no affiliation whatsoever.
All right. Does David Carpenter currently play any role with the debtor?
He was a long-time advisor and close confidant. Over the last 8 months, Dave and I have not had much contact.
All right. Mr. Hauser went over whether you're keeping current post-petition on rent, and you answered that.
Mm-hmm.
Is there any pre-petition rent that you owe to landlords before the petition date?
When we took over the Temecula location, there was some rent from the former franchisee, and there's a disputed issue with that landlord. They want to hold us responsible for the rent. We're not in agreement. So rent, pre-petition, had been kept current.
All rents for all stores that you were responsible for the rent?
There may have been late by a week or two, but not on a month-to-month basis.
So nothing was owing as of the petition date?
I can't say that emphatically. There may have been something owing, but it wasn't to the point where the landlord was filing a pay or quit situation.
Understood. Payroll, were you current on payroll as of the petition date,
We're always current on payroll.
including 1099 employees?
Yes.
And have you been paying your financial advisor his monthly fee?
You talking about Brian?
Brian, yes.
I gave Brian a small amount of money, $5,000, for work he was doing, raising capital. He has not been paid as part of the bankruptcy process. We're hoping to, through the DIP financing, that he can receive compensation. Does that answer your question?
The $5,000 you paid him, was it before the bankruptcy?
Yes, I believe it was before the bankruptcy.
And it was paid by the debtor?
Not Ultimate Brands, it wasn't paid by Ultimate
Who
Brands.
paid it?
I don't remember which account it came out of.
Okay. And do you have any unsecured debts of a significant amount that aren't listed there?
The business or personal?
The debtor,
The debtor.
that aren't listed on your schedules?
No, I think we've captured 99.9% of it.
All right. Moving on to the budget. In your status report, referenced a $250,000 cash infusion coming in at the end of July. Do you recall that?
We had done a draft of a cash flow, which has subsequently been amended, and it's going to be amended again. So at the time, that was a placeholder cash flow statement.
What place was it holding?
Well, these are estimates. These are pro forma estimates, so they continue to be amended based on real expenses, what the real numbers are. And so it's constantly be updated. Every week it's being updated.
Did the money come in?
What money are you referring to?
It said that there was going to be a $250,000. Now we refer directly to the status
You're
report.
referring to the DIP financing.
I'm referring to your status report.
It's referring to the proposed DIP financing, which we thought we would have on file by now.
Okay, so just to clarify, so it's one and the same.
Yeah, we're beating the
Yes.
dead horse.
The amounts are different, but it's the same.
It's
Okay.
the same.
Yeah, in negotiation with DIP financing, we at the time were looking at a time frame. There was discussions about receiving it in tranches. So that spreadsheet represented what we were estimating at
That's
the
the
time.
first installment.
So at the time of the status report, you estimated that you would have already received DIP financing by the end of July.
Yes.
When you did the status report, were you relying on that $250,000 to make the numbers meet?
No, the company is essentially cash flow.
Well, slow down.
Like,
We
we
just
do
testified
this.
that your post-petition delinquent on your taxes, your post-petition delinquent on your rent. So the company's not cash flow positive, okay? Unless you have a wildly different understanding of cash flow
Our cash
positive.
collateral budget shows, I mean, Michael already went over it, Mr. Hauser went over it. We went through it. By week 6, he's negative. So yes, we need the DIP financing, which we've been through this. And we're going on 3 hours now.
We'll move to the cash collateral budget. I see on week 3, at the end of this week, that your ending cash balance is negative $107,000. Is that correct?
No, it's not correct. It's not even
Am I not seeing that right?
It is right, but the point is, I do
That's
think
an estimate.
we kind of cover, just as far as, I think we've established a couple things.
All right.
Number one, this budget shows that the case is administrative and insolvent and absent DIP financing, it can't go forward. So I think they've admitted that on the record, and we kind of went over it a lot. So if you have some fertile ground on that issue, that's great.
What I'm getting at here is,
Yeah.
how are they negative $100,000? I mean,
Oh, no,
where's that coming from?
No, your point's well taken. I said the same thing. I said when you get to, how do you have 100 negative? Pick any line item here. Negative 22,000, negative 100. How do you work that way? And I think we established that a condition precedent to this budget being approved is the DIP financing. There's no judge. I mean, maybe for 10 days on a good day you can get a judge to approve this, but there's no judge who's going to approve
A negative budget.
this budget on a standalone basis, particularly when it doesn't have line items for professional fees and other items. So I think that is, and we're both going to be at the hearing on Thursday. So this is not going to, go forward without a DIP financing facility in place. I mean, like I said, the judge can do what he wants, but I don't understand why he would do it.
I don't need to beat a dead horse. I have a couple more budget questions, but they're not directly related to that point. The expenses in your budget, are those based on past expenses?
The expenses are based on our experiences of expenses in the past.
So if you're spending X on a line item, generally that means that you would have spent around X on that for prior months.
That's correct. So if we budget a certain amount for product purchases, then that's budget. Now, there are variable costs in there. Legal's a variable cost, Rhino's variable cost, accounting can be a variable cost, bookkeeping can be a variable cost. We also have the authority to cut expenses in various areas in payroll as well as 1099. So we represent a budget that we think is reasonable for operating on a go-forward basis, not under an emergency basis. So the budget that's provided is based on our history and keeping people employed and keeping resources actively engaged.
Understood. So your budget calls for $500,000 or $500 in advertising spend.
How much?
$500 per week?
We budget because we have online Fetch Rev, we have various with our technology partner, Zenoti, for example. So we have, it's really a very modest marketing promotional budget, but yes, we budget on a weekly, monthly basis. And then we have individuals that are actively involved in advertising and market like Jerry and Alexa. So.
And that money would be under payroll or 1099?
Yes, we have, for example, Alexa and Jerry would be under payroll or 1099 working on various advertising activities that are specific to the franchise organization.
Is that budgeted out separately?
No, that's, everything's on a consolidated basis.
I mean, is the amount you spend for certain people, personnel who are involved in advertising, is that separately budgeted and their time accounted for?
Well, what we have is we have it lumped together, so we don't, Cynthia has it all detailed out, but for the purpose of the cash flow performance, we have various categories lumped together.
All right. And so the 500, separate from the lumping out together the personnel, the 500 spent per week, does that reflect what you've done over the past 6 months to a year in terms of advertising spending?
Well, that's not the only advertising spending, because you got to take the personnel and you have to take other elements and components, and then you put that all together. So the advertising spending is the people as well as the actual hard dollars that are
Separate from the
used.
people, what, and you're not here, what are the other components?
Well, the components are, you've got your website management updates, you've got your social media for every one of the locations that's managed. You've got various resources that are paid for, like FetchRev and Zenoti and others. So I can't give you right now a complete breakdown of month to month, but there are a lot of components to the marketing aspect of the equation.
All right. There's also a $500 item for marketing. What's the difference between advertising and marketing?
It's nuanced. Advertising, marketing tends to cross over quite a bit. My whole background is in advertising and marketing and teaching at the MBA level, so there are a lot of variables.
All right. And does that $500 reflect your historical spending over the last 6 to 12 months?
What reflects our historical spending is if we were to do an actual marketing analysis, then we'd have to take personnel as well as specific resources, online, social, database, where for the graphics, the site that we manage for the graphics. So it would be a completely separate analysis. What we have in our cash flows is on a consolidated basis for all companies combined.
This cash flow is on a consolidated basis?
Yes, it's on a consolidated basis.
All right.
Well, let's just step back for a second, stop. Okay, first of all, UFI, when it assigned all of its royalties to the debtor, has no other income stream. So
That's correct.
So it's really, say consolidated, you're consolidating the debtor with nothing. So we can, and UFI has no expenses, and I certainly hope they're not included in this budget.
No, this is all consolidated when the gentleman, what's your name again?
Jeremy.
Jeremy. When Jeremy talks about the past and our experience for designing these budgets on a go-forward basis, my understanding is he was questioning me as to how it was constructed.
Okay.
On a go-forward basis, it's under one umbrella, one entity. Everything else is history.
We get it, okay. All right.
So it's fair to say, among all the entities, historically, the marketing spend was historically $500
No,
a week.
no, absolutely not. I know where you're going, but no. That thread will not turn into a rope.
Because, go on. Why wasn't it $500 a week?
No, we'd have to do a complete audit if you want to get into a marketing spend allocation audit, which we're not obligated to do by
He doesn't want to
contract.
confirm, I can see, he doesn't want to confirm that these are his numbers
No, I'm not going to
prior
do
to
it.
filing. That's his budget projection. Cynthia and Brian drafted it.
No.
Scott reviewed it. To go item by item right now, we couldn't say off the cuff because I don't have it in front of me.
All right. Have you ever received any complaints from a federal or state agency regarding your franchise, or who regulates franchising or franchises?
Yes.
You being the debtor,
You mean Ultimate Brands
Ultimate Brands.
or Ultimate Franchises?
We'll start with Ultimate Brands.
I don't think it's been against Ultimate Brands.
All right. Ultimate Franchises?
Yes, of course.
When was the most recent one?
I think the most recent is there was an issue with Minnesota about a gentleman opened a second salon and a gap in terms of the filing of that particular location, which he handled himself. So, but Minnesota, we're aware there was an issue.
Did they bring an enforcement action against?
I haven't seen any enforcement action.
So what action did they take? Oh,
I'm only aware through arbitration that I was made aware of it actually through the arbitrator. Not the arbitrator, but the legal counsel for one of the franchisees.
Has Ultimate Franchises or the debtor ever been subject to an enforcement action from a regulator of franchises?
Years ago, and again, this was in dialogue with legal counsel for one of the franchisees, going back to California, back to 2012, there was an issue that was resolved between the franchise attorney and the state, and it was properly disclosed in the item 3.
It was resolved by Ultimate Franchises attorney?
The franchise attorney for Ultimate Franchises and Ultimate Brands, when we were getting ready to expand, there was an issue, and legal counsel, to the satisfaction of the state, as well as our legal counsel, resolved it, and it was disclosed in item 3 per the request of the state, and the language was approved by the state.
Did you pay any penalties?
It was a small penalty. I think it was $2,000 or $3,000.
And no actions by any government authority are still pending against the debtor, right?
Not that I know of. Minnesota maybe, but I haven't seen anything myself.
Is the franchise attorney who you've referred to a few times still employed by the debtor?
No, that was Leslie Peugeot, and she's with Play of Cook, and we haven't worked with her for probably 2 years. We haven't franchised for a long time, so.
All right. That's it.
Okay. Is there anyone else who would like to,
Yeah, you guys go ahead.
Good.
Go ahead, see where you go, and I don't wanna cover the same ground either. I don't wanna separate you from your power cord. I'm sorry.
No, we're sorry.
I'm listening intently.
before you get started, I just want to ask a few follow-up
Sure.
questions. Starting with calendar year 2018, so we had talked about how many employees were W-2 employees, and I think the number we came up with was 58. Does that sound right?
Sounds about right.
Okay. And so in calendar year 2018, if I were to be a W-2 employee and I got my W-2 form issued to me at the end of the calendar year 2018, who was the identified employer on that?
In 2018,
Yep.
it would have either been Ultimate Brands or Ultimate Franchises. I believe that we switched the W-2 payment at that time to Ultimate Franchises, and that's when Adidas was involved. So I don't know the exact answer for that, Michael.
Okay. And for 2019, what would the answer be for who the W-2 issuer was? Would it be
I think the contracts would still be under Ultimate Franchises.
Okay, so when I asked you,
I'd have to confirm that with HR.
why would if I was an employee of UBI, why would I be getting a W-2 from UFI? Who's the franchisor?
I don't recall the reason that we chose to do that, other than we treated Ultimate Franchises and Ultimate Brands as one and the same.
Okay, so that statement's pretty clear, that there was a commingling of just about everything between these two entities.
That is correct.
Okay, all right, go ahead.
You actually led me to exactly the point I wanted to make. In a similar line in your
I'm so
statement.
sorry, I didn't catch, I just want to.
Oh, I'm sorry.
It's okay.
I've been here so long, I thought I'd
I
appear
know.
already. My name is Eric Mitnick, M-I-T-N-I-C-K. I'm an attorney for M.J. Patterson and Wheatstrong Enterprises, who's listed, unfortunately, as the largest unsecured creditor in the case at a little over $2.3 million. Okay, continue on. As Mr. Hauser just indicated, I have a follow-up question because the statement of financial affairs for UBI, Ultimate Brands, the debtor, shows no payments to anybody over $6,000 within 90 days of the case. Yet, you testified that rent is current at all locations and employees are paid. Were those obligations paid by a different entity other than UBI? Or does that need to be amended to
Yes.
reflect the payments?
Ultimate Brands DIP account was just recently set up, and so everything is in the process.
Okay, but the
We've
DIP
already-
account is not established until after a case is filed. There's a question on the statement of financial affairs for ask for payments over $6,000 collectively to any creditor, which would be the 90 days before the case was filed. Who paid the rent for your corporate locations for the 90 days before the case was
That would
filed?
have come from Ultimate Franchises or one of our
Okay,
accounts.
so the reason why that those rent payments aren't listed in the statement of financial affairs is because UFI was making the payments, not UBI?
UBI was not making the payments.
Okay.
We had
so-
consolidated everything under Ultimate Franchises. One of the reasons that we weren't working out of Ultimate Brands is because there was a lien on that account by Centerpoint, so we had to work out of another account.
So you shifted those obligations to UFI to avoid a lien that was on the account that was against UBI.
The objective was to make sure money came in and money was used to pay obligations.
So put it another way, in order to avoid the interruption of flow of funds, because you knew that Centerpoint had put a lien on the bank accounts of UBI and could put a lien on other bank accounts of UBI, you started doing business through UFI
Yes, and
to pay expenses of...
That's
of
correct.
Let me finish. To pay expenses of UBI.
that is correct.
Okay. And when did the Centerpoint lien, when was that filed?
That was filed, I think it was filed around October of last year.
So since October of 2018 to the time this bankruptcy case was filed, you were not utilizing UBI bank accounts for all intent and purposes?
I don't think we've been using UBI for quite some time, bank accounts.
Even preceding the Centerpoint lien?
Preceding, I think we were using it for some of our hard money loans to Happy Rock. We had a UBI account set up that we were servicing Happy Rock out of.
For the ACH?
Yes,
Okay, but for other purposes, since October 2018, all funds have pretty much flowed through UFI accounts?
yes, we'd have to do a forensic, but I believe that's
Right,
correct.
without doing it detailed in the
Yeah.
weeds, generally speaking. Okay.
Yes.
I'm sorry, go ahead.
Oh, thank you for following up. Mr. Griffiths, today you've talked often about the consolidated group, consolidated entities, consolidated business functioning. Which entities are within the consolidated group that you've been mentioning?
Two Ultimate Brands is dormant, but the consolidation that we represent is for the three main businesses, Ultimate Franchises, 2 Ultimate Brands, and Ultimate Brands.
Great Griffiths is not included?
Great Griffiths is a separate entity that exists for a brand that I own personally, which is the Griffiths brand. And so that exists for future initiatives that are Griffiths specific. But Griffiths is not an asset.
Are you involved in any businesses that are in the same line of business as UBI and UFI?
I'm currently not doing anything that's in the same line of business. I have the Griffiths trademark, which I own, and it's my desire in the future to take that brand and do something with it, but I haven't, as of yet, done anything with it.
So as we sit here today, you're not operating any men's hair salons?
No,
Please let me finish the question.
I'm sorry.
You're not operating any men's hair salons under any other names other than UBI or UFI or 188?
No.
What about Great Griffiths 2?
Great Griffiths 2 and Great Griffiths. Great Griffiths 2 is an entity that's set up for future activity, but it's currently not doing anything.
Because the business that's indicated on the statement of the Secretary of State shows that Great Griffiths 2 is in the business of franchising. Please explain that.
Okay, I will. What it says is we have an FDD that exists for the business of licensing and franchising, but it also says in there that we're not licensed to franchise in every state. And as of yet, we have not consummated any contracts relative to Griffiths in that entity. So it's dormant, it's not functioning.
And what business would that be licensing?
Well, we would focus on the Griffiths Ace Grooming and Shave Bar to expand that as a business activity. That would be its primary purpose.
Okay, and a name shows up in some more recent statements that you filed in California for the consolidated group. There's an H. Wong who's listed as an officer or director of Ultimate Corporations. Who is H. Wong and what does he or she do?
My wife's name is Hanyi Huang, is her maiden name.
And please spell the first name. HANYIHWONG.
And so this person
Is
who
that
also goes by
Loretta. Goes by the name
that
Loretta.
is also AKA Loretta.
AKA Loretta.
I apologize for
Okay, that explains that.
You know,
I appreciate that. So, in one of the documents I read online regarding your franchise endeavors, in addition to 188, it also mentions the trademark name of Griffiths Grooming and Shave Bars. What is that, and what is? Explain how that fits into the ultimate business.
yes, we just talked about that, but to refresh your
To just
memory.
just talked about it with respect to Great Griffiths, or with respect?
We
to
just talked about it. You brought up the FDD, you brought up Great Griff 2, and what I explained the purpose of that was in the future to develop a chain of the Griff's Ace Grooming and Shave Bar barbershops. And it's a business endeavor that I hope to pursue in the future.
But it has not been pursued by the Consolidated Ultimate Group.
And not as of yet.
What about True Solutions for Thinning Hair?
True Solutions for Thinning Hair is not a trademark. It is a description of a value-added service where the strategic objective is to not just be a place for haircuts and a better experience. When I created the category years ago, that was a real differentiator. But today I feel to really differentiate and really excel beyond others who have copied us, which is, I'm flattered. But we need to be a destination as well. That's where you'll travel 15, 20 miles where we guarantee you'll get your hair back or you'll keep it longer. And we have various strategic alliances with Bosley and a company called Capilli. We think it's a game changer. We think it's a huge opportunity.
Is that through Ultimate, or is
That
through-
has been through Ultimate Franchises, where we are executing that as a value-added service.
Is
And
that included in your operating budget, your cash collateral budget, or additional revenues you
Yes.
put in for that?
yes, yeah, that's all in there.
Okay, what about Griff's Mobile Barbers?
Doesn't happen, it's an idea. It's future.
I only have about 5 minutes.
Okay.
The cash collateral stipulation that was filed indicates that Ultimate Brands used $487,000 approximately in cash collateral. What was that money used for?
I have the faintest idea. I don't know what you're referring to.
What he's asking you is from the time this case was filed on June 28th through the time you entered into the stipulation with the attorneys for the bank,
Right.
that you acknowledged that you had used the receivables from the royalties and whatever without getting the permission of the lender, BVD. And there was an amount that was put on that. I think it was $482,000.
Okay.
And all he's asking you is from June 28th through the time you entered the stipulation, what do you use the money for?
Okay. Well, we have 3 payroll periods. Okay, so each payroll period is almost $100,000 each payroll period. We have rents. So we're looking at approximately $40,000, $45,000 a month in rents. You have product purchases. You have the other gentleman's comments. You have various areas of marketing spend.
Okay.
You've got your 1099 resources, such as accounting, bookkeeping. Andrew in Minnesota's on a 1099, and he's a consultant on operations. Chris has been on 1099 in development and marketing. And you have, various miscellaneous. So
Was that money paid by UFI or UBI?
well, as we indicated before, there's been commingling of all the funds. So it's been paid by wherever the cash has been going in, it's been used to pay. It's only recently that we set up the DIP account and cash is now flowing into the DIP account.
So approximately when did you set up the DIP account?
It was set up, I think, over 2 weeks ago, and we've arranged for the ACH from the corporate store. Not the ACH, but all the credit card processing is now flowing into the DIP account.
So for the month or so prior to when you established the DIP account, the money that was being used that's described as use of cash collateral could have come from UBI, UFI, to Ultimate, or anybody within that group of companies that you call consolidated.
I believe so, yes.
Do you believe that the bank or BVD 660 had a lien on the assets of UFI at the time those payments were made from the UFI account?
I know that the predecessor bank, which started out as the Community Bank of Santa Barbara,
Right.
became the Ojai Bank and then the Bank of the Sierra, that there was a loan converted to a term loan, and that Dave and I signed documents.
I think we already established he doesn't know about the asset seizure
Okay, so
filing.
he doesn't know whether the bank documents included a lien against UFI as opposed to UBI.
No.
I don't recall the details, and with David's counsel, the question of our perception of setting up Dave buying the loan and our perception of it, hopefully it's going to be a moot point, but I don't know all the nuances and the details.
Okay, when you say Dave bought the loan, do you know how much he paid for the loan?
I don't know how much he paid for the loan.
And how do you know he walked the line?
Because we were informed, our general counsel was informed when Dave filed suit against the companies and me personally. You know, it was turned over to general counsel, and
Did you transfer the revenue stream from UFI to UBI, so UBI would have assets to pay the bank debt?
no, we didn't do that, and I think we talked about why that didn't happen.
Did you transfer the trademark, which was in your name apparently for quite a long period of time, to UBI to again provide assets to allow UBI to pay the debt so you personally wouldn't have to?
We've talked about that, the trademark.
It's a yes or no question, sir.
Did I transfer it?
Well, you had testified that the trademark was in 18A, was in the S&L Griffiths Trust, but you thought maybe it was supposed to be in UBI, and then you had testified that you had transferred 18A to UBI.
What do you want me to say yes to or
Well,
no to?
did you do that in order to create assets to get the bank paid off?
No?
Very well. I don't have any more questions.
Okay, thank you for your time.
Thank
Appreciate
you.
it. See you on Thursday.
Yeah, it'd be fun.
And is there anyone else who'd like to ask questions? Sir, please come forward, state your name and who you represent.
Hello, my name is Hakan Yasar Kilik. I represent myself.
Mm-hmm.
I am one of the creditors of Ultimate Franchisees.
How do you spell your last name, sir?
Kilik.
It's on the
Oh,
schedules.
okay. Sorry, I'm sorry. Just
Yeah, yeah, it's there. It's Hakan
Thank you.
Yassin.
You're welcome. And we have a default judgment under Ultimate Franchisees. And I want to ask a question about Ultimate Franchisees. Will Ultimate Franchisee receive any money from franchise royalty from now on?
I don't understand the question.
Who?
I mean, will there be any receiving money from franchisees in terms of royalty fees in Ultimate Franchisee's bank account?
So you just testified, I understand your question. Are you asking when the franchisees pay their royalties every month, which is around $75,000, where will that go?
Yep.
His testimony was that they've now changed the ACH accounts so that they no longer go to UFI, that they're going to go into the bank account set up for this bankruptcy. I understand that you meant that's not going to make you happy because you have a judgment against UFI.
Yep.
I understand that, and,
Yep.
and I gave that speech about how.
Yeah,
But for right now, that's the way it's set up.
gotcha. So what is the reason that you change, you transfer the money from Ultimate Franchisees to Ultimate Brands? While you have some O's under Ultimate Franchisees company?
We've always seen Ultimate Brands as the parent owning 100% of Ultimate Franchises, and it's to the benefit of the creditors, particularly the secure creditors, that everything is on a consolidated basis. And so now with your case, there's more complexity, but we're not here to argue the merits of the case.
It's frankly not that complex. Unfortunately for you, at this point, all the assets of UFI have been stripped and is now property of this estate for now. And so I don't want to belabor the point. It's unfortunate for you, but that's where it is right now. But you understand that, right?
Yeah, yep.
Okay. So, I mean, you can ask a few more questions, but...
Sure, but I want to understand if it is legal.
Well, I
to
think
transfer
I think
money.
everyone in this room is wondering.
Take a vote.
Well, I don't want to make light of it. My point is, we're having a hearing on Thursday on whether or not this budget is going to be approved. There's going to be a hearing probably on a DIP financing. I mean, there's going to be a lot going on in the next few weeks. And there's parties that are going to take different positions, and I don't know how kindly or unkindly the court's going to look on that particular transfer that took place the day before the filing. Beyond that, I don't think there's anything anyone could say here to make you feel better or to change what's already occurred for now.
Yep. And my last question is that,
Yeah.
you know,
Oh, just so you know, so your former franchisees are no longer operating the store?
no. I gave back the store.
Okay,
There was an agreement.
I
I
understand.
gave back the store, but I couldn't get my money.
I understand.
So that's why, you know, we sued and we have an
I understand that.
Yeah.
Okay.
for judgment.
Okay. All right. It sounds like there's a lot of people in your boat. You may want to speak to some of these other people here and see if you have some, allies, so to speak, in your cause. But everyone's in a different kind of position. Some people are still franchisees. We've got former franchisees. We've got a former partner who bought the note. That gentleman there represents some former franchisees. So everyone's in kind of a different position and wants to see a different outcome. You obviously would love to see that money sent back to UFI so you can collect on your judgment. I have a feeling, though, there's kind of a big line on there, too. So I'm not sure you're the only creditor of that estate, of that company. But I think that's all we could really address. So I am sorry this happened to you.
No, that's okay. But, you know, I want to understand the reason why, you know, instead of...
I'll tell you, I asked him under oath, why did you do this? And his answer was, and I think we've gone over a lot, was, I wanted to roll it up into a single entity.
Mhm.
And I think we've said that repeatedly, is he's treated everything as the same. Doesn't make it right, it doesn't make it... It's just, that's where we are today.
Gotcha. But why did he file the bankruptcy under Ultimate Brands rather than Ultimate Franchisees?
It's a good question. You can ask him that.
Why did you prefer to file bankruptcy under Ultimate Brands instead of Ultimate Franchisees? Because the revenue is in Ultimate Franchisees, and the payroll is under Ultimate Franchisees, and all the revenue and expenses are under Ultimate Franchisees.
Well, there's more revenue under Ultimate Brands than there is Ultimate Franchises. Their contracts, the contracts can be transferred at any time without notice. Ultimate Brands owns 100% of Ultimate Franchises. There are various levels of creditors, and part of it is to simplify everything, because at the end of the day, the assets have to be attended to the needs of the court relative to the pecking order of the nature of the creditor, of which I'm the largest one. So I'm in the same boat as everybody else. The odds of me getting a substantial portion of mine, and I've always been the lender of last resort. Nobody was there to lend money to the company except me for quite some time. And now I'm at the same level of risk that you are and others are. I will say that I did my best to try to do workouts with everybody. There were some people, I think Dave Carpenter would have been reasonable. I think we were on a good path to a solution. But there were some, and I'll be pejorative, there were some real bad apples in the equation that made it impossible to avoid the bankruptcy. Impossible. And we didn't have to be where we are today, I guarantee it. But unfortunately, there was a tipping point and I had no alternative. And I've run a lot of businesses over the years. I've never hurt anybody I've done business with. What I've gone through in the last 2 years is almost unbearable. And to see people like you, a good person, hurt bothers me deeply. But we had a situation that escalated where, and I'll say it again, some real bad apples just made it impossible to avoid the situation that we're in now. And we just have to play it out. But I guarantee you, I will be hurt probably more than anybody else. So it's unfortunate. I created something, I built it, I put my life savings into it. I think we still have something wonderful. Hopefully others will be able to take it forward, but we'll see. So I apologize to you.
Thank you. I don't have any other questions
Okay.
since he admitted, about the, the situation. So honestly, I really wish good luck for you to manage, your company and, to at least make profit and, pay everyone else here.
I'd love to see everybody get paid, even my enemies. It's just not my nature to not honor my obligations. But, 40 years in business, and this is the first time I've experienced this.
Thank you.
Okay, thank you for your
Thank
time,
you.
sir, I appreciate it.
Thank you.
Okay, Ms. Sorry.
Yeah, I'm gonna be quick.
Okay.
Good afternoon.
Thank you.
My name's
Hello.
Chris Stratton. I'm an attorney for multiple creditors, including DJ Buns, the Harders, and Dwight Tusky. I'm gonna try to go quickly for you. We've kind of heard the pejorative "we" here, and I think from the testimony, and if you can confirm for me, the pejorative "we" has seemed to have been two Ultimate Brands, and UFI. Is that correct? Are there any other companies in that collective "we"?
No.
Okay, so earlier when you testified, we haven't franchised in a while, was that the "we" you were speaking of?
Yes.
Okay, perfect. So, there was discussion just a second ago with Mr. Mitnick about Griff's Shave Bar and a FDD related to Great Griff's 2 Corp.
Yes.
Perfect. You're familiar with that document?
I'm familiar with the conversation that we just had.
No, that's not, wasn't my question. Are you familiar with the FDD?
Yes, I am familiar with the FTD.
Great. When was that created?
It was created, I believe, September of last year.
Okay. And did you review that document before it was issued or published?
It's gone through multiple drafts, and I have reviewed drafts, but it hasn't been, nothing has been consummated out of that initiative so far.
So I have on my copy that the
Right.
issuance date of the FDD is October 1st, 2008. Is there an FDD after that?
That might have been the latest iteration.
Okay. Did you review that document?
I reviewed the latest iteration.
Okay. Was that ever published?
When you say published, what do you mean?
Was it published out into the public forum, online, anywhere else?
It hasn't been put into any public forum that I've authorized.
Okay. And who's Adam Holtz?
Adam who?
Maybe I'm saying the last name incorrectly. Hulse?
Are you talking about Andrew?
Or is it Andrew?
Yeah, Andrew
Yes, I'm
Holtz.
sorry. Andrew Holtz.
Andrew Holtz is a franchisee of 18-8, and he is working with us on a consulting basis. And in terms of my retirement and moving my creations on a go-forward basis, I want Andrew to be the person to run that entity.
What kind of consulting does he provide and to what entity?
He provides consulting to Ultimate Franchises, Ultimate Brands, on the whole basket, working with primarily Bridget and the True Solutions, improving the compensation structure, marketing techniques, the rollout of True Solutions. So he is a senior level thinker for Bridget, who's our VP of Ops, to interface with, and he's done a very good job.
Does he receive any revenue from the Great Griffiths?
No, not as of yet. As I shared earlier, Great Griffiths has not done anything yet. It is a work in progress.
As of October 1st, 2018, it intended to also franchise at 18-8. Is that correct?
It has a licensing, it's licensed to use the 18-8 brand for the purpose of franchising, but nothing has happened yet.
Who granted them that license?
It would have been granted by Ultimate Brands.
Okay, and would it surprise you that it says in this document that the trustees of the S.L. Griffiths Trust dated 3/14/2014, the trust own the marks, confidential information, and branded system and have licensed us to use and sub-license that intellectual property for Griff's Shave Bars?
Yes, that's a matter that I think we've discussed a lot, and that trademark, that situation has to be adjusted so that the trademark is under Ultimate Brands.
Do you know when, well, strike that. It says that the trust is dated 3/14/2014. Was that the settlement date of the trust?
Settlement, I don't
When it was
understand that
formed,
word.
when it was
That's
formed.
when it was formed.
Okay, so prior to that, not at all.
That is correct.
Okay, so on or about that date, the actual ownership of that particular trademark, was that funded into the trust?
The trademark of the 18A existed under Ultimate Brands. Okay, the trust was not set up to acquire the Ultimate Brands trademark.
Was there a entity that owned it before Ultimate Brands?
The entity that owned it prior to 2008 was Mana Concepts. That was the predecessor corporation.
And UBI was formed in and around 2008, correct?
August 2008.
Okay, and Mark Applegate sued you when?
Mark Applegate was a partner in Mana Concepts. He didn't sue us.
He sued you,
The
correct?
personal was released. It was canceled.
I understand.
And the suit that prevailed was against Mana Concepts.
But prior to the formation of UBI, he sued you, Mr. Love, and Mana Concepts, is that correct?
Prior to the formation of Ultimate Brands, he sued Mana Concepts, and then Ron Love and myself were named in the suits, and that was subsequently dropped.
Understood. The judgment was only against Mana Concepts.
That is correct.
Okay. As it relates to UBI being formed in 2008, what was the purpose of forming UBI?
The purpose of forming UBI is when the Great Recession hit, all of the lines of credit, everything was canceled. I'm sure you're old enough to remember what that was like.
To who?
To our businesses, to the Mana Concepts business.
Okay.
Okay, and so my discussions with Ron at the time, we couldn't get any financing, and the only opportunity to finance growth was through franchising. And so I formed the corporation, raised outside capital, of which Dave Carpenter was one of the early investors, my mother-in-law, me, and we raised capital, and we went through the process over the next 2 years figuring out how to franchise.
What was the purpose of forming UFI a year later?
We felt that having an entity for the corporate stores and having an entity for franchise activity, just to have some degree of separation, which we did not maintain, that changed pretty quickly, but that was the original purpose.
So is it safe to assume, based on your testimony today, that since 2009, there's basically been a commingling of funds between UBI and UFI?
Ultimate Franchise is 100% owned by Ultimate Brands,
Wasn't
and they were functioning as one and the same.
Okay, so almost since the data formation
From
of UFI.
very early on, I couldn't give you a diary, but the funds have been moving back and forth.
Okay, and I think you testified earlier that there was a settlement with Mr. Applegate. Is that correct?
There was a settlement through Mana Concepts with Mr. Applegate.
Was that after he obtained a judgment against Mana?
He received a judgment, and then there was a settlement after he received the judgment.
Okay. And do you recall what the terms of that settlement were, if you can discuss it?
I don't remember the exact terms, but it was right around $200,000.
That include the attorney's fees from Dylan?
Yes.
Okay, so is that what the $100K from Dylan is on this?
No.
Okay.
I had never been through a lawsuit in my life before, and was stunned that there was a lawsuit. Dylan was a superior attorney to the legal counsel that we had. We don't have to discuss the merits of the case, but they prevailed. And I was so impressed with Dylan that when we needed general counsel, I asked Dylan if he would be our general counsel, which he was for a while.
Okay. In this FDD document for Great Griffiths, it also discussed two ultimate brands, but it doesn't really give me any idea about the corporate entity. Is that a California entity?
Two illegitimate brands. The state misspelled it, so it's pronounced illegitimate brands.
So that's why I couldn't find it.
Yeah.
Okay.
Two illegitimate brands was originally set up because we want our product development, R&D, and our innovation, our education training. We felt that just having that under another entity. Now, if I had to do it all over again, I wouldn't do any of it. It would be all one entity. But at the time, we had pretty grand vision, and so. And it's really in the last 2 years that, as we've throttled back, that the extra corporations haven't really made sense at all.
Why was if UFI was still an ongoing entity, why was Great Griffiths going to begin to also franchise the 1818?
Great Griff is a brand that I created, named after my father, and something that I've wanted to do for a long time, and have another brand, a premium barbershop concept, and something that I would be able to develop or work with the team to develop, as a new business opportunity. It's stalled right now for reasons I think everybody in everybody in the room can, I'm sure, appreciate, but hopefully in the future we can do something with it.
The Griffiths Organization, Inc., when was that formed?
Griffiths Organization?
There's been this nebulous reference to Griffiths Org, but there is actually the Griffiths Organization.
The Griffiths,
Inc. Is that the
yes,
is
the
that
Griffiths
the
Organization, when I had my consulting business going back to the year 2000, that was active in the world of consulting, major brands, successful, probably should have stayed with it. That was formed, I think, around 2000. And when I stopped doing the consulting to focus full time on the franchise business, we kept it as a private corporation, and the benefits, what revenue we do get, has gone there into that entity.
So when you receive funds as a 1099 contractor, employee, whatever it is, from UBI, UFI, whoever's been paying you over this time, is this where the money's going?
Well, we haven't taken a lot of compensation, but when we do, it would go into that entity. That is correct.
Is there any other place where compensation due and owing to you and your wife for the services that you're performing?
No, I don't think we've taken it. We haven't taken it as a W-2, and we would take it as on a consulting basis. Is how it would be structured.
Okay, so the answer is no other entity.
No other entity.
I saw, like Mr. Mitnick, I saw the name Wong, but I also thought I saw a name Han Yi Lee. Does that sound familiar to you?
Yeah, that was brought up earlier. Han Yi Huang is my wife's maiden name.
Okay, so it's Han Yi H.
Huang.
Wong.
Yeah.
Is that correct?
Yes.
Okay, and the Griffiths Organization, Inc., where's that located?
Out of our house.
Okay. Do you have a corporate office in Nevada?
The Great Griff 2 is set up in Nevada, and the reason we did that is setting up a particular franchise entity in California is a mistake. So I decided not to do that on a go-forward basis.
Why do you think it's a mistake?
Just there are certain states that are very, very difficult for franchise organizations, and so going into Florida, Texas, Rhode Island, Delaware, Nevada are the states that are most recommended, and I don't know why it wasn't recommended to me in the beginning when we set up Ultimate Franchises.
So that would be the legal address for Great Griffiths 2 correct?
Correct.
Okay. Does that have an office in Nevada, or is that just like a post office?
No, that's a rental
Okay.
location.
When UBI gave a corporate guarantee for Mana as it relates to Mark Applegate, do you
Yes.
recall when that was?
Yes, that would have been in the very beginning when, well, early on, when we worked out the settlement. And there was a settlement, funds were tight. As funds got better, I was contacted by Dylan, and we agreed to start making payments. They pressed hard for personal guarantees. We said no. But we felt that a backup guarantee through Ultimate Brands would be acceptable. And the vast majority has been paid off, so it did work out.
Was it UBI or was it UFI that guaranteed?
No, it was UBI.
It was UBI?
Yes.
Okay. On UFI's franchise disclosure document, did you ever disclose that settlement?
Yes, we disclosed that there, early on, we disclosed that there was a relationship or there was an issue with Mana Concepts. In subsequent FDDs, legal counsel felt it wasn't necessary to have it on an ongoing, I don't know why.
And that was Ms. Peugeot?
Ms. Peugeot.
Peugeot. How do you spell that?
Leslie Peugeot, Pujo.
Is Tasha Griffiths your daughter?
Yes, my daughter. So you saw her name in there, but she's coming out in the next draft.
From, as being president?
Yeah, that was a placeholder, and so I've talked to Andrew about being president.
Are there any written agreements between Great Griffiths 2 and UBI?
No,
Are there any written agreements between Great Griffiths 2 and UFI?
no,
How about Two Ultimate Brands Inc.?
no.
Okay, so that's just a document that means nothing.
Essentially,
Okay,
it means hopefully opportunity, but I think for the purpose of what we're going through, it doesn't mean anything.
Just let me, how much longer do you think?
90 seconds.
Okay.
Let me just look real quick. The mobile unit trailers that are referenced in that FDD for Great Griffiths 2, who owns those?
They don't exist yet. They haven't been built. It's an opportunity we want to pursue.
Was that opportunity ever within UBI or UFI?
We did represent in Ultimate Franchise in a past FDD the mobile opportunity, which never materialized. That was in the 2017 Ultimate Franchise FDD.
Earlier we were talking about your personal residence. Is that owned by the trust?
Yes.
What else does the trust own?
Excuse me.
It owns the Griffiths trademark. It owns the property. I think that's it.
Perfect, that's it. Thank you.
Okay, thank you for your time.
Appreciate it.
Sure.
Okay, so this meeting will be continued to August 12th at 10 o'clock.